Welcome to the Foul Play YouTube channel, open mic number 155. And today, I hope everybody's ready with their good listening ears to Travis give us some, how the process kind of works with the post-conviction. Really thank him for taking the time to do this. He's busy. He's a working lawyer. So we have a lot of questions that have already been sent in. I'm sure we're going to get more in the chat, and that's fine. I know he's willing to help everyone, from beginner to more advanced, that really kind of understand the process about how things will really work in court, in the criminal justice system. So with that said, we were just finishing up a little bit of last minute getting documents and so forth. We're going to greet everyone, and then I'm going to give just a little brief thing before we start, and then we're going to be out to the races with this. So let's not dally anymore. I'm going to say hello to everyone in the live chat. I mean, in the Discord channel, I'm sorry. And let them say hi right quick. Voices are important. So first up, welcome Alice.
Hi, Jack. Hi, everyone on panel. Hi, everyone in chat. Nice to see you all. Looking forward to what Travis has got for us tonight.
Excellent. Thank you, Alice. And from across the pond also, that guy, Andy B.
Hi, good evening, Jack, and good evening, everybody else, panel and chat. I won't say much. Let's get on with the special guest. Thank you very much. Looking very much forward to it.
Thank you so much, Andy. Darkside, another one from across the pond.
Hi, everybody. Thanks for joining.
Thank you, Darkside. And Cherie, I don't recall.
Hi, everybody, and welcome to Open Mic.
Thanks, Cherie and Sister Susan.
Hello, everyone. Happy Sunday. Hope you're all having a great day, evening, night.
Thanks, Susan. JD.
Hi, everybody, and welcome to chat.
Thanks, JD. Sister Rhonda.
Hey, everyone. Hi, everybody on the panel. Welcome, Travis, and welcome to everybody in the chat.
Thank you, Rhonda. Cal. Hello from down under.
Good morning, everyone. It's lovely to be here.
Thank you so much. I know it's really early for you. And then, of course, Travis, the main guest here.
Hello, everybody in the panel. Afterwards, I got to talk to Andy B. why in his photo he's got a SSL board with Yamaha NS10 sitting on top, but we'll save that for a later day. And hello, everybody in chat. Because of the interface, I can't see your comments, but I know that folks on the panel will keep me updated on questions. But hello, everybody out there, and sorry we had to reschedule this. I got ill a couple of days before we were scheduled, but we're all back on track, and we'll see how much we can get through this morning, this evening, wherever you may be. And Jack mentioned, if we need more time and need to do another one in the future, we will. So don't panic if we're not proceeding through everything. We're gonna get to every question that was submitted in Discord, plus try and get to all the questions in the chat, and I'm looking forward to it.
Absolutely. And if it takes 2 or 3 parts to do this, people get tired and they want to, call it a night, that's fine. We don't have really, the only thing that's really pressing that we're waiting on is Judge Angie, and we have no idea when that ruling is going to come. So it's fine. It's not a problem to schedule a second or even a third to get through this. Yeah, I'm certainly willing to do that. So, before we start, I talked to, and I don't really say this all the time, but I think it's important to say it now. Please, everyone, be civil to each other. If you have questions, that's fine. You can state it civilly, even if you're all ramped up about a question. It's fine. Just state it civilly, so it takes, we can gather more of what you're really looking for other than the emotion that you're feeling. I've tried to approach, for the last long time, I've tried to approach things that way. And I found that it works better. You actually get a truer answer instead of, you may feel better for just a minute saying a bunch of stuff that, you're pissed off about or whatever. That's not really why we're here. We get the emotion. We do. We get ramped up too. All of us. But in this, and I think in most of the things we present, let's just try to remain civil. If you have a question, try to word it in a way that we can understand. Even if it's you only have 200 characters you can type in the live chat. If you have to make 2 parts to get your question, just write part 1, part 2. The mod's going to be watching. So that's all I've got about that. With that, Rhonda, can you see the live chat and can you say hello to the ones that look like we've got, 30 or 40 people in before we get rolling? And I'll pull up this document and get it on screen.
Can I just quickly say something? Sorry. Thanks, Travis, for recognising my SSL desk and NS10 monitors. And we can talk about that now if you want to.
Good.
I shall shut up now and let the expert do his thing. Sorry about that, but I had to mention it.
Thank you, Andy. Go ahead, Rhonda.
We have Rumor Has It, Angie Dickinson, Dark Side of the Moon, TTM Fangirl. She was actually early. And that's pretty exciting. She's pretty excited about that. Good for you. Katie did it. And Catnip is in our chat, which is great. It's good to see you, Catnip. JD also on the panel. Inexplicable Susan also on the panel. Allison Wrongful Conviction Land also on the panel. J-Jax also on the panel and running the show. Double D, it's great to see you. Cher. Let's see. Mark Kaz, it's great to see you, Mark. Sherry Lynn Pontillo, great to see you. And Anthony D, how are you doing, Anthony? Pete Moss, great to see you. Jeff Jones, we're so excited to have you in the chat. And Iced Coffee, yum. Iced Coffee. Let's see. Carol Cousins, great to see you, Carol. Aaron Murin, thank you for that really kind compliment. We appreciate you. Kelly McCallion and Graham Moss, great to see you, Graham. And Anthony Hills, you're in the chat. Great to see you. And let's see. For right now, that's all I can see. If I missed you, I really am sorry. We'll try to shout out to you during a break or something.
Sherry Lynn, I think you missed.
Rhonda. Did you get under your scars? Under your scars is with this tonight?
Oh, yeah. Yep, under your scars. Sorry. Oh, and Paul Ward. I thought I got under your scars earlier. Sorry about that, my friend.
And Sherry Lynn.
Got Sherry Lynn.
And Carol.
Alligator 57. Hi, Alligator 57. Ali Softball Life as well has joined us is in the chat as well. They're a bit further up. So if anybody else is doing this, we're very sorry. Put another wee hello, and like Rhonda says, we'll get back to you.
Yep, I must have missed the further up one. Sorry. Justine J, great to see you. Welcome.
I apologize for having to do this, but once we went live, Prism did something really weird. I've never seen this before. Trying to get this adjusted where it's readable on screen. Let me try this. Part of the live chat's going to be blocked on the side. We'll just have to live with it. That looks like that's as good as it's going to get right there. I can zoom it in though. Okay, thank you so much, Rhonda and Alice, for introing everybody. I'm going to now turn this over to Travis. You can do whatever you like. How, preface this however you want to do it. As I said, whenever you need me to move the slide, you just let me know, and I will. All right, Travis, it's all yours.
Okay, thanks. Thank you for having me, first of all. So just to follow up on something Jack said earlier, one of the things, and I've been in the supporter communities going back since right after MAM 2 came out, primarily with Eric Jose's group, and then migrated over here and a lot of the same friends. But the analogy I always gave is that supporters, you kind of wear 2 or 3 hats. I for sure wear multiple hats, and one is, you're a supporter of Brendan and or Stephen. Most are, fervent supporters of both men, and so as part of that support, a lot of people, and your group here are, primarily researchers and into researching and delving into the facts on a, very deep level. And then there's the legal aspect of it. And so anything I say, I'm trying to explain the process. By no means, as part of the explanation of that process, do I mean to imply that I agree with a particular court decision or the way a particular judge ruled on something in connection with these cases, because frankly, the vast majority of the rulings don't agree with. What I'm here to try and do is explain how the courts may have rendered a certain decision, or what it was about the briefs that maybe led to a certain court decision. So that's first off. Don't shoot the messenger. I'm just trying to explain this stuff to you. And then in the questions, I'll try and answer anything I can. Some things just can't be answered, but I'll try to explain, why it can't be answered at this point, or it may have some assumptions about the legal system that just aren't totally in mesh with the way they do things in Wisconsin, or something of that nature. But we'll get started. So right there at the top, thanks for putting that up, Jack. I can't see it, but I'll let you know when I'm down, getting ready to go to the next page. One of the first questions we had, great question. Can you explain exactly what post-conviction means? How is it different? What are the main misconceptions that people have about post-conviction? That's a wonderful question. So first, let's explain what it is. So I have at the top, what is post-conviction? And the 3 terms in the cases that you'll see is appellate counsel, post-disposition counsel, and 97406 counsel. And all of that is part of the post-conviction process. So we're going to define these terms just real briefly. Post-disposition counsel. So after a verdict comes in and you're sentenced, you in Wisconsin, you have to file what's called a notice of intent to seek post-conviction remedies. And as part of that, if you are going to appeal, there's a couple of things that require you have a hearing first, and we'll get to those in a minute. But the attorney that files the motions after the sentencing like a motion for new trial, but before an appeal is filed, are referred to as post-disposition counsel. And their role is to file motions with the circuit court immediately after the client's been convicted and sentenced, and that includes evidentiary hearings. And then if you lose those, you need to file a notice of appeal, and that is appellate counsel. And then after you've gone through the normal appellate process, which is what I've just described, post-trial motions, and then an appeal, which is also referred to as a direct appeal. And you lose that, you're not completely out of luck. If you have been denied constitutional rights, you can collaterally attack, is what it's called. It used to be called a writ of habeas corpus, but every state's codified them, and in Wisconsin, that's referred to by the statute number, which is, and I have a typo there, it's 97406. And the courts frequently refer to attorneys who are representing defendants in a 97406 action. They'll frequently refer to them as post-conviction counsel. And so it's terribly confusing. And one of the books I read in Wisconsin and one of the court cases said it's more accurate and salutary to refer to Section 97406 motions as collateral motions. Well, I didn't like that. Or simply Section 97406 motions. And the attorneys as 97406 counsel. So I hope that answered that first part of that question. And then what are the main, how is it different? So I think when they asked what post-conviction means, they were referring to 97406. And how it differs is, in a direct appeal, and we'll go through this in a minute, you can appeal certain things, but a 97406, you're much more limited what you can ask the circuit court to look at, and then ultimately a court of appeals. Let's see. What are the main misconceptions? Go ahead.
Yeah, I just have briefly, because Avery did this. This was in 2013, I think. He filed a pro se, and several people have, invariably over the last long time asked me what a pro se motion is. Can you just briefly explain that while you're talking about this here? Unless you're going to do it later.
No, I'm going to get into that 2013 motion, but okay. I'm glad you asked that because that's important. Pro se just means you represent yourself. You don't have an attorney. So when you hear the term pro se or filed pro se, filed on your own behalf, you don't have a lawyer representing you. So I'm glad you interjected that. That's important to understand. So if you don't have an attorney, and we'll kind of get into that in the next section that follows this, but if you don't have an attorney for your 97406, you're filing it pro se. So what are the big misconceptions? And one of the big misconceptions about all appeals, 97406 or direct appeal, is that they're easy. You can relitigate the whole case. And as you all have become aware in following these cases, you can't relitigate. You're stuck with what happened at the trial unless you can show that your attorney was ineffective, or you can develop new evidence, or you were deprived of evidence that should have been given to you, which happens. All of those things happen, but they're rare. And we'll get to this also in a minute. The way defendants are looked at, viewed, is completely different. And in the trial court, in theory, you're presumed innocent, and you have all of these presumptions in the favor of the defendant, presumed innocent, along with many, many other things. And so, you know, on appeal, once you lose and you go up on appeal, there's what's called the doctrine of finality that works against defendants in many, many ways. And we'll get into that in a little bit also in more detail. And I don't think this misconception is as widespread as it once was, but certainly in the 70s and into the 80s, there was a view that defendants were getting off on, quote, technicalities, unquote, that it was easy to win on a technicality, which is, you know, somebody coined that phrase, you got off on a technicality. Anytime that happens, that means that somebody's constitutional rights were violated. So in theory, that's a good thing that they got off because somebody violated their rights. They coerced a false confession. They planted evidence. They withheld exculpatory evidence. You know, they didn't receive a fair trial. Their attorney just sat there and did nothing. They had no representation, effective representation whatsoever. Yeah, those are technicalities. They're constitutional law violations. But that, I think people understand that they've restacked the deck in the last 20 years. So that's my answer to that first question. And so the next thing we're going to do is talk about the right to post-conviction counsel. Is that next heading, Jack, still on that first page?
Yeah.
And someone asked a question about the differences in what the standards are in post-conviction. Are they the same as the Strickland standard? Strickland's a U.S. Supreme Court case that came up with the standard of the level of representation the Constitution guarantees everyone since Gideon, and then other cases after that. So first you have to know, when do you have a right to post-conviction counsel? So now we understand the differences of these different attorneys. So these different proceedings, post-disposition, appellate, and 97406. On appeal, it's firmly established in Wisconsin, Texas, in the federal system that you have the right to counsel. It goes beyond the trial all the way through a defendant's first appeal, the direct appeal. And on post-conviction motions, you're required to file a motion for new trial if you're going to, on appeal. So you've been sentenced, convicted, sentenced. If you don't believe that your attorney was effective, you really need to do it right there if you can, and you need to have a hearing on it. And you call in those attorneys, you have your new appeal attorneys do it. So you're entitled to be appointed an attorney to file those motions and have them heard. You also need to have an actual hearing before you appeal for new evidence that you discover right then and there. That there's new evidence you learn about right after the end of the trial. You need to bring a motion for new trial based on that new evidence. So you're entitled to an attorney for that. And then if you don't succeed on that, you need to appeal to the Court of Appeals in your direct appeal. Then you're entitled to an attorney through that entire appellate process. You are not entitled in Wisconsin to an attorney for your 97406 motions, your motions filed as a collateral attack. And because you're not entitled to an attorney, at the very bottom of that first page, accordingly, even when a defendant has representation in state collateral proceedings, that's a 97406, may not allege that he received ineffective assistance of counsel. Coleman v. Thompson from 91, U.S. Supreme Court. And Wisconsin follows that as well. They say you cannot bring an ineffective assistance of counsel claim against your 97406 attorney. So now we're down in the next page where it says appeal, Jack. And I'm just going to quickly go through. So the appeal, this is the thing at the direct appeal you're entitled to as a matter of right. All you need to do is within 20 days let the circuit court know that you intend to appeal. It's after the conviction and sentencing. It's referred to as a direct appeal frequently, matter of right. You can file it if there are no issues. You're still entitled to file it. And so I want to try throughout whatever we talked about today to bring this back to the Avery case, since everyone's very familiar with that, and it's in the middle of a 97406 process. So after Stephen was convicted and sentenced to life without possibility of parole, he was appointed 2 attorneys from the Wisconsin State Defender Service that specialize in appeals. And I'm so bad with names. It was 2 ladies.
One of them was Hagopian. I can't recall the other one.
Yeah, the Armenian name. That I can't remember the other either. But anyway, so they took over, and because they were going for ineffective assistance of counsel, which I'm going to try and abbreviate as IAC, one of the claims was that, and keep in mind, and this frequently happens, Dean and Jerry cooperated. Jerry Buting actually testified. They cooperated with the appellate attorneys in trying to show that they were ineffective for agreeing to allow the substituted juror. And the other big issue they had was the court's rulings on Denny. And so they had a evidentiary hearing held by the same judge that tried the case. That's totally normal. If anyone wants to know the reasoning behind that, they can put a question in chat. I won't go into it now. But and then that was denied, and then he filed an appeal, and then that was subsequently denied. So an appeal, the requirements are you got to file a notice of intent within 20 days of the sentencing. Then you order the trial transcripts. Court reporter has 60 days to prepare those transcripts. If you file you must file a post-conviction motion in the trial court or a notice of appeal within that time. If you are going to file the motion for new trial, like they did in Stephen's case, the court must rule on that within 60 days, or it's automatically deemed denied. And then either after that 60th day, or if it's ruled on earlier, the post-conviction motion, you need to file your notice of appeal within 20 days. So who handles post-conviction appeal on behalf of the state? I notice in some of the chats on foul play, you all have noticed, it's different attorneys here and there, and so I wanted to list those out, and actually I've skipped ahead. So, Jack, I'm still on the bottom of that second page, number 2. So, in some appeals, criminal appeals, the trial attorney, like Dean and Jerry, represent their clients on appeal. Others, they appoint new counsel. In the federal system, the federal courts prefer that trial counsel stay on the case, and the theory being that they're familiar with all of the rulings, everything that happened in court. It's going to be more efficient for them to find errors and so on and so forth. In Wisconsin and many other states, they feel it's better that brand new counsel come in because trial counsel may be reluctant to say that they were ineffective. I don't find that to be the case in practice. I find that if they think there may be something could have been done better or completely different, they'll insist that their client get another appellate attorney to at least look at it. But anyway, that's what the theory is. And in Wisconsin, they favor new attorneys to come in and be the appellate counsel. And so you saw that with the Defender Service appointing 2 new attorneys. So let's skip down to number 4, and let me know when you have that, Jack.
Got it.
Okay. So what are the common issues for either these motions that are heard before the actual direct appeal and the appeal? And I wanted to go through these quickly just so that you understand what's different, going back to that original question we answered at the top. Boudreaux. Sorry, Boudreaux gets upset about something. I don't know. Anyway, so what are the common issues on a direct appeal? So the big one is errors in ruling on the evidence. That is something that is not available typically in a 97406. So anything that was admitted over objection, anything that was denied over objection, jury instructions that were objected to, and the real big one in this case was the Denny. One of the other ones is other acts evidence, but the judge excluded what they were seeking to get in on other acts with respect to Stephen. So that's not appealable because he kept them all out. And hearsay is normally, you object to it and it should be sustained, but it doesn't rise to this super serious level unless it violates the confrontation clause. Down to the next page, sufficiency of the evidence. This is a tough one, but if you have it, it's really good. There literally has to be no evidence in the record concerning one or more elements of the offense. So there could be 99 witnesses. Well, let's talk about Stephen's first case. Like 15 or 16 witnesses. Do I have this right? Or am I thinking of another case that alibied Stephen?
That's right. That's correct.
And one witness, Penny, who, for whatever reasons, misidentified. So you had one person saying, no, he was there. They don't weigh the evidence. The only way you could get a sufficiency of the evidence is that at trial, she equivocated and said, well, it might be him, but I really can't tell. The court would grant a motion to dismiss on that. But if they didn't, you'd have a sufficiency of the evidence. And if you win on sufficiency, why that's good is that is double jeopardy. They can't retry you. All of these other things, if you win on all of these, any of these other issues, errors in the ruling, and they order a new trial, they don't dismiss. Then ineffective assistance of counsel is another big one. And let's just go over what the Strickland requirements are. And there's two-pronged test you'll hear all the time. Number one, lawyer committed error of either commission or omission that was so egregious that it's tantamount to no legal representation at all. It's referred to as the effectiveness prong. Then you have to show materiality. But for that attorney error, the result of the proceedings would have been different, the prejudice prong. That's usually the one that's pretty difficult to overcome. And then it's not a requirement, but I wanted to point out, trial strategy cannot be ineffective assistance of counsel. Any decision on the part of the attorney that was a matter of trial strategy or professional judgment cannot be the basis for an ineffective assistance claim. And those of you who have dug through the pleadings on ineffective assistance of counsel in the 97406 motions, you'll see that Kathleen Zellner has gotten affidavits from either Dean Strang or Jerry Buting, and you'll see in those affidavits language like, I can't think of any reason I did this. I can't think of any reason that I didn't do this. Or on the Brady stuff, they'll say, I never saw this, I never got it. But when they're saying, I don't have any reason for doing this or not doing this, what they're saying to the court is, I didn't do that because it was strategy. Or I did do it because it was strategy. Because if it's strategy, you can't prevail on it. You can't use it as ineffective assistance of counsel. So then the other big class of stuff on direct appeal is in drug type cases, but there was a Fourth Amendment issue that was tried to be raised as part of the appeals in this case. And those are heard pre-trial, and you all are familiar with the pre-trial transcripts and all the different things that were ruled upon. Well, you bring what's called a suppression motion, saying that this evidence was seized in violation of the Fourth Amendment, and if that's granted, they suppress that evidence, and then the state determines whether they have enough other evidence to proceed or not. If it's denied, you can't appeal that decision until your direct appeal. So that's also very common. Okay, now we're at 5 at the bottom. Who represents the state in these various types of appeals? So in the post-conviction, those are the ones filed right after the trial and before the appeal. And Strang and Gone, Strang and Gone. No, what am I thinking? Kratz was there, but he wasn't very involved. And then who was the other main trial attorney?
Fallon.
Fallon and Gone handled most of it. And you see, district attorney represents the state in all post-conviction actions in the trial court. AG represents the state in felony appeals in the Court of Appeals. So you have those other attorneys from the AG's office, and they've come and gone, but they're always representing in the Court of Appeals or the Supreme Court. It's not a misdemeanor appeal, it doesn't apply. And then the AG represents the state in all matters in the Supreme Court, whether felony or misdemeanor. So then, next page, number 6, Jack.
Got it.
It petition for review. So what happens if you lose on appeal? Well, you appeal to the Supreme Court, but appeals to the Supreme Court in Wisconsin are discretionary, and it's the same way in Texas. Discretionary means exactly what this says. The Supreme Court has the option to accept an appeal or not. And so what you do is you file a petition for discretionary review. And what you're trying to do is show the court why this case is important enough for them to look at. Unlike the Court of Appeals that you have a right to appeal to, you have to convince the Supreme Court in your petition for review that your case is important enough to do. They only hear a small number of cases. They rarely, in Wisconsin, grant oral argument. The Court of Appeals fixes errors. The Supreme Court, they're focused more on public policy and how to interpret their state constitution. And so it's just like I said, purpose of petition for discretionary review is to convince the Supreme Court, talking about the state Supreme Court of Wisconsin, that the case presents some important issue that requires the attention of the highest court. The appeal presents more than a mere error-correcting analysis. Petition for review is not an opportunity to re-argue cases from the Court of Appeals. So that takes us through the regular appeal process. And the next thing I was going to go into is 974-06 questions. But we can take a pause here, see if anybody on the panel has a question, or if anybody in chat's got a question on what we've gone over so far, and then I'll go through the list of questions to see if there's any I can answer now, but based on what we covered. How's that sound?
Sounds great. And I do have a question. I don't know if Alice or Rhonda or whoever has been watching chat for anything, but so basically the Supreme Court is just like the U.S. Supreme Court, SCOTUS. They pick and choose what cases to hear.
That's precisely correct.
Yeah, I thought so.
And so I can't remember on the direct appeal, on the juror and the Denny issue. We know they lost at the Court of Appeals, obviously. If they did a petition for review, I'm sure they did. I can't imagine that they didn't. But we know for a fact that on the 2017 974-06 and the other 6 motions that they decided as part of that, when all of them, and all of Stephen's claims and issues were denied, Zellner's office filed a petition for review in the Wisconsin Supreme Court, and the ruling on that is, they deny review or decline review, and basically meaning the Court of Appeals decision stands.
Excellent. I did want to welcome Dr. Silkman. Hello, Doc.
Oh, hey, Dr. Silkman.
Hey, it's good to be here. I need a lawyer just to understand all the legal aspects, but it's been fantastic. Thank you so much for doing this. It really has helped, really to help understand what's happening in the case. Thank you so much.
Oh, thanks for having me. And we'll do our best, and we'll keep trying until everybody understands what they want to try and understand.
So Alice or Rhonda or one of the mods, I really haven't been following chat that closely. Is there anything that we can maybe get Travis to answer right now at this little pause?
Somebody in chat was asking, do the judges have an unlimited time to respond to something, or do they have a limit on when they have to respond?
This is a current question.
Yeah, so at the circuit court level, there's some rules of judicial administration, some ethical rules that require the circuit court judges to send in a report every month to the presiding judge, letting them know if they have any cases that have been submitted. All that means is everyone's had an opportunity to file their brief. That's over, what is it, 60 or 90 days? Jack, you know.
I'm going to say 90, but I could be wrong, Travis. I just can't remember. I think it's
whatever.
90.
Yeah, so it's the letters that have been, filed that everybody knows about. If they're supposed to report that they have, which matters have gone beyond, let's just say it's 90 days, and if if they're sick, they get an automatic another 90. And but why this came about, why these rules, why the legislature passed these rules, is there was one judge 10 or 15 years ago that just wasn't doing anything, wasn't showing up, wasn't handling his docket, and so you got an elected official, and they're not doing what they're supposed to be doing, what the taxpayers are paying them for, and they couldn't do anything about it. And so the legislature came up with some, between the legislature and the Supreme Court, who has jurisdiction to administer the courts also, they came up with these rules. And originally the rule was, if you had any cases that were beyond the 90 days, they would quit paying you. Well, the Supreme Court said they thought that was a little harsh, and so they took that part out of it. But
they did.
That was the purpose, is to monitor these things. And so, in Wisconsin, you are supposed to report that if you've got cases that are extending out, and there may be reasons for that. There may be that can't decide the case until somebody gets out of the hospital or something, but you are supposed to report those, and so that the presiding judge of that district can determine if some judges are overloaded and they need to do a realignment of cases. But yeah, there's a time limit of sorts. The presiding judge has the authority, if things get too bad, to remove a judge if it gets super bad. But and then there's, when a case is finally submitted, that's typically the moving party files a motion, the opposing party files a response, and the moving party is entitled to file a reply. And there's certain time frames for all of that. That day that the reply is filed, the last pleading, or the deadline for filing the pleading, even if they don't file one, is supposed to start that 90-day period running. But if something gets filed in the middle there, it's going to extend the time. And my recollection is the first complaint or letter, which wasn't filed with even the right person, you don't file it with the circuit court, that the 90 days hadn't even expired because of a supplement. And I'm not even sure the 90 days or whatever the time frame has expired, because Kathleen Zellner's office has filed a motion to supplement, which hasn't been ruled on yet, to add the new affidavit. Do I have that right, you guys?
Yeah, she filed her 974, the third 97406, January 24th, I think, of this year. And then I can't remember the exact date, Travis, but sometime after that, I don't think the 90 days had expired yet. She filed this supplement with Thomas Buresh that allegedly saw the RAB, blah, blah, blah. I don't remember exactly when that fell, but what you're saying is when that happens, it really kind of resets the clock. Is that right? Am I understanding that right?
Yeah, it's not defined, but it would have to, because, and I think what Kathleen presumably was upset enough about the first letter to cause the filing afterwards that got filed about wanting to withdraw it, because, she wants that in there. And so judge is just like, okay, well, you're upset that I'm over 90 days on the January filing. So it's not from January. It's the date that the reply is due. Zellner's reply to the state's response. So if it's 30 days, that puts it in February, and then they can extend by stipulation. And the final dates are all in their docketing system, but filing a motion to add a new pleading or document in that's connected to that same motion, I can't see how anyone, whether it's the presiding judge or anybody else looking at it, wouldn't say, well, that's going to trigger a new 90 days from the date that the last pleading is due, last deadline.
Right. Yep. Well, I think that makes sense. I didn't really think of it in those terms, but I guess in my mind that I didn't really expect a reply. I mean, I think probably we're getting since. Hey, originally, I really thought in my mind when she filed in January, I was really thinking June or July, just because of the enormity of the case and how complex it is. But then once the supplement was filed, who the hell knows?
I just looked that up. She filed that on May 26th.
Oh, there you go.
Has the state, has there either been an order for the state to respond, or have they filed a response?
No.
No.
I don't believe so, no.
Yeah, my recollection was that early August would have been too soon. That needed to be late August.
Yeah.
To have a valid complaint, but
Hey, Travis, we have a question from chat. Rhonda, can you read out Q's question I pinned up there?
Yeah. Hugh Fraser asks, has there ever been an attempt to bring in something akin to clean hands doctrine into America criminal court with regard to an officer of the court? If so, with what result?
Okay, so clean hands doctrine is typically you can't ask the court to give you equity. So there's legal remedies, which is typically money, and then equitable remedies, which are non-monetary, like returning a piece of physical property, or moving somebody off your land that you don't want on there, are some of the equitable remedies. And one of the old doctrines from the common law is you can't seek an equitable remedy unless you have clean hands. So and that means you can't be the bad guy. And so I'm not sure the context, if they want to supplement on that, but where because what threw me as a police officer, I think, was in the question. So things similar to that, but not quite. Equitable things were argued like estoppel in the 974-06, we'll call it the second one, the 2017 one that got denied, about that there was an agreement between the state and Kathleen Zellner on things that they would test and a time frame, but the court issued an order, a decision, while that was going on, and then, you know, in the decision they talk about that, you know, which I didn't really understand where they were coming from. They just got hyper technical and were able to bury themselves in these hyper technical rules. And you know, it is true. You can't assume and rely that the court's not going to issue a decision in a 974-06. And so the better practice would have been, in hindsight, of course, you know, I'm saying this, for, you know, Kathleen to update the court and copy the prosecutor's office. Hey, we're in the midst of working out a schedule to test evidence, and we're going to ask that you put that in abeyance. We'll be sending you a formal stipulation and order. And then if it were me, in hindsight, of course, you know, I would have said, if the court would like a status conference on it, you know, we'd be happy to do that. But, you know, they didn't, and she ruled, and she made equitable arguments about estoppel and things like that. So there's another doctrine, it's called forfeiture by wrongdoing, that you forfeit the right to, for example, confront your accuser if you kill your accuser. So if, you know, in murder cases where a defense might be the state's trying to bring in statements from the deceased, and the defendant says, well, you're violating my right to confrontation, and there's a doctrine in law that says, well, you forfeit that right to confrontation by your wrongdoing. And then unclean hands involving a police officer, I really am going to need something a little bit more definite on that, but
Travis.
yeah.
Travis. I think he was referring to, I think he said officer of the court, not police officer.
Then I'm sure that's what he was talking about. Yeah, as a matter of fact, you know, it happens all the time. So there's attorneys referred to as officers of the court, but you know, that's generally what, you know, prosecutorial misconduct is, and you know, if you can establish it, there is a, you know, that can result in a case being dismissed. It can result in a prosecutor being disbarred, but you have to understand, it's, you know, where this stuff has happened. For example, the big one everyone will know is the Duke lacrosse team case. Everybody familiar with that?
Not following. I remember it well.
Okay, so you know, it's one of the most egregious cases of prosecutorial misconduct in the, you know, annals of American law, and he he doctored expert reports that exonerated the lacrosse team. And he was disbarred. The case here in Texas, in my backyard in Williamson County, is the Michael Morton case, and they buried exculpatory evidence of a third-party suspect who turned out to be the actual suspect.
Oh my God.
And so that judge, was disbarred, kicked off the bench. He was prosecutor, then he became a judge, and then thrown off the bench. And so yeah, there are remedies for police officers or officers of the court with unclean hands. But these types of things aren't arguable. They're that arguing evidence, for example, and going over the line, that you're arguing, you're exaggerating what the significance of the evidence. That's not going to get you into this realm. The realm that these guys were in, there were smoking guns, doctored reports that they were able to show, Nifong doctored, that there was a cover-up trying to backtrack, hiding the exculpatory statement. These things are dead bang clear, and so it's you're usually not going to find them on things uttered like in closing argument, for example. Just telling you kind of what the thresholds you need.
That's that the Duke lacrosse case is horrible. I'm going to read a question, and then I think, was that you, Alice?
Yeah, it was me. Yeah,
there's a question. It's a little further up in the chat, and I paused it. It's from Anthony Hills. I got it pinned. He asks, is the judge required to report to the defense counsel as well as the Chief Justice the reasons for the delay?
Geez, let's see. It's only been 3 days since I read the requirements. It's like a monthly report. I don't think the requirements of it are detailed, it's just really not the way anybody wants to be going in this thing. It's not. The deadline's not even up, and it's going to take what it's going to take. The person that needs to complain about it is Kathleen Zellner, nobody else.
That's right.
Not Steven, not his fiance, not me, and she can certainly, if is getting frustrated that it's over the time, but it hadn't even been over the time. And it's not even going to impact her. It's not like they're going to throw her off the bench or do anything else. I think she was 10 days late on the other one, which would surprise me that Kathleen didn't do something preemptive on the one. I think it got to 100 days or something. And that told me that the DA's office was maybe leading her along.
Yeah. TTM Fangirl had made a comment a few minutes ago, specifically about this last letter. Would this necessarily reset the clock again? this recent letter?
The letters don't reset the clocks. And it's not even that's not even filed in the right place. I'm surprised they even filed it, and not returning it saying, we're not responsible for this. You need to send this to this office.
Right.
And they filed what's called an ancillary case number. It's the one with the X's. All the other ones have letters to show that it's a criminal appeal, civil appeal, or some other kind of appeal, however they categorize it. They just made it an auxiliary one, XXX, and there that thing sits for the whole world to see. It's just, but I understand the frustration and all of that stuff too, but it's just not a good move filing it premature twice.
I agree. Alice, did you have one?
Yeah. Well, I mean, I've got a few questions that people have put in the chat earlier, but I'd just like to make a comment, and to everybody who has put in questions in that in chat, it's fantastic. Please keep them coming. The mods are taking notes of your questions, like we try and do every week. We are taking note of them. We're storing them. If we can't get them answered for you tonight, we will pass them on to Travis if he hasn't already answered them for you. So please just stick with us. If your question doesn't get answered tonight, it will be answered. And don't forget, you've also got the comment section after the video is done, and there's a specific room on Discord where you can post questions. The questions that Travis is answering and things like that to us now have been preset, and he's managed to be able to go and look things up and check things over and double check and things like that. So please don't get frustrated or anything like that. We will get you to your questions. If it's not tonight, we will do it in the next one, but your questions are being noted, okay? Anthony Hauser had a question a wee while back, and it was, what does SCR stand for, and what's the use of having SCRs if local courts don't abide by them?
So that's Supreme Court rules, and those are those ethical rules, and so this is going back to the letter probably, and I don't know that she's got hundreds and hundreds of cases, but I think the problem is she's not over the time limit yet. It doesn't run from January. It runs, if it gets reset, it's a new date now. And I don't know if she ordered responses by the state or not. Normally, the state doesn't need to oppose the motion, a 97406 motion, unless ordered to respond by the court. Because the vast majority of 97406 motions are pro se, and everybody knows what pro se means now, right? Thanks, Jack. And the majority are pro se, and the majority of them look like Stevens' 2013 motion. They're written from forms in the prison law library, and they're just not comprehensible, and they're not making any claim, and a judge can just look through those and deny them summarily. But I'm pretty sure SCR is going to be Supreme Court rules, and they're rules for the administration of justice that attorneys have to comply with, and then In Texas, we have a separate set of rule for judges, but that's my only answer on that. And even if she was over, they turn it in, and she can come up with any reason that she wants, and saying, yeah, I was ill for half a day, and that gets you another 90. So, I'm just not really sure. The impatience of the community is about 100 on the list of priorities on this thing, and the top one needs to be the captain of the ship driving the thing, the strategy and things with that, the attorney in charge. But it's frustrating on the time. But obviously she was upset about the first one, and I don't know the circumstances that led to the second one, but I checked the timing on it, and I don't even think they're out of time until next week.
Yeah, I can only imagine those letters were really upsetting to Zellner. Just knowing how she is, how we know her. So, anyway, Alice, continue please with your next question.
Yeah, this is another question that was early on, and it's specifically for you, Travis, and it's from Mark Kaz in chat, and he says, Travis, if you were Stephen's attorney when he was released, would you have advised him not to have a firearm anywhere near him due to the previous conviction? I think this was a massive mistake.
Oh, absolutely. Absolutely. But so I'm going to answer that, and then Jack, can you put up the list of questions that I sent you earlier, and I'm going to start to go through some of those while
you're answering.
A few more.
While you're answering, I'll get that loaded.
Yeah, absolutely. That was from Kaz, right?
Yeah.
But hindsight being 2020, so the gun was actually the owner. So Jody was living in that red trailer, and she knew Raleigh, and Raleigh was letting her stay there for free. And Stephen was living, I think, at his folks' house for a while, and then moved into that, looked like a sheep wagon, a bass sheep wagon.
Shanty, yep.
Okay, and was sleeping in there, and then he did an interview and said he actually preferred it. And people who are institutionalized for that long a time, it's a big adjustment. Just being in the real world, and that Shawshank Redemption, it's not too far off from that. People locked up 20, 30 years coming out, even with tremendous support, still struggle. So one thing led to the other, and we know that he ended up moving into the trailer with Jody, and Raleigh's 22 was in there, and the black powder rifle, and he wouldn't have had a problem with the black powder. Yeah, absolutely. I wish that he would have said, hey, I can't have this gun in here, Jody. I need to move it down to my parents' house or something like that. And it's heartbreaking. But they live on this compound, isolated to a certain degree. I'll tell you, being a 5-year-old kid growing up in a junkyard, probably, it would be paradise for me and my friends. We would have loved it. All those cars would have been spaceships and boats and tanks and who knows. But understand, getting older probably wasn't pleasant, but just kind of in your own little world out there. It's all your own family, and they subdivided that one end of the piece of the 80 acres off to Raleigh. But other than that, it's all family, and so yeah, it's heartbreaking and tragic. But honestly, I probably wouldn't have thought to remind my client getting out of prison, make sure that he didn't have any guns in his house. But so I can't say I would have done any better that the attorneys did that got him exonerated. You meet him at the prison gate, get them home and get them the resources they need, and that's there. Let me go through a few of these questions, and Alice, if you can get a couple more ready while I go through these, we'll start hitting them. How common, often, for Kathleen's original PCR, it's going to be post-conviction relief, but we're going to start calling it 974-6. Okay, got Boudreaux under control. How common, often, for Kathleen's original PCR motion to be, this is number 2 under general questions, Jack, to be heavily procedurally barred based on supporting evidence she had in it. So this was Jeff's question from the other channel, and I thought, good. In my paper, we may just probably going to need to do this for another time, but we can go back to it. But she had about 14 claims in total. 7 were procedurally barred. At some point, we should go through them just so we can look at and decide for ourselves how detrimental it was. But about half got procedurally barred. I have them listed out in the paper. You have, Jack, and then another 7 they decided on the merits, which means they looked at what they needed to look at. Didn't turn out our way, but they weren't thrown out on a technicality. It's really hard, how common, often, for a motion to be that heavily barred. It's just a matter of the lawyer that's writing it. Some that are going to be barred, you put in there just so that the court is aware of it. Maybe they see that they look at the thing cumulatively. They look at all of it. And even though they're going to throw it out, you want them to know that this expert did this and came up with this, or this person said this, or whatnot. And so, I don't do I don't do any post-conviction work. I refer it out. We have board-certified specialists that do nothing but post-conviction work, and I refer out to them. And then fortunately, I don't even have many that go, or any go bad, that I even need post-conviction. But what I know about the number of claims that get procedurally barred and whatnot is from reviewing cases, trying to, know about this case. So reviewing other Wisconsin cases and whatnot. And I don't think there's any that are like that, but, it doesn't happen very often that a defendant, it happens all the time, they file their own pro se 97406. It's super rare that an attorney, let alone an accomplished, experienced 97406 attorney or collateral attack attorney comes in and takes over, spends a bunch of money on testing to see what they can develop. It's so rare, but her dismissing the appeal rather than asking it to be remanded so that she could amend it, I think there was a few of the procedurally barred claims. There were a few on there because of that dismissal. But I think there were others that they were going to be procedurally barred anyway, even if she hadn't have dismissed the 2013 97406.
Travis.
So, go ahead.
I think one of the big ones was the bones being given back to the hall box. That was procedurally barred, inexplicably. That is.
Yeah, that was a huge one. So, well, let's go through a few more questions, and I'll take you to that part, and we can. I think we should follow up on that at some point before we end today.
Yeah, Travis, I would like for those that really don't understand this process in the court. And this can just be pretty brief because in reality it was a brief thing, but explain later on, not now, the pro se motion that Avery had filed in 2013 and then Zellner coming in and dismissing it. And I think this is important that people, I didn't understand it for a long time. I didn't, but I do now. Anyway, that's for later.
Okay, let me see if we can knock out these four and then see if we got some more from Alice, and then maybe we can go to the list. Let's see. So I think I answered that. In Wisconsin, when an item of evidence becomes procedurally barred and new evidence comes to light supporting the previous barred item, can it then be unbarred? Okay, so this is a good question. Why I like this is it's easy to kind of conflate and cross over the things. It's really evidence isn't procedurally barred, it's issues. And then, of course, evidence that you would present at an evidentiary hearing to support that issue, is now rendered irrelevant. And so it has the effect of barring evidence, but it's really issues. So what they're talking about is if new evidence came to light supporting an issue that had been barred, can it be unbarred? Well, it doesn't get unbarred, but if new evidence comes to light and meets all of the qualifications, and I've got all of that in here whenever we go over it, it met all of the qualifications, and it's truly new, then that would unbar the other evidence, because you would have so I actually thought about this before. Dr. Silkman, are you still awake, or did you fall asleep?
No. I'm here. I'm listening in. At the end of this,
so
I can apply for my law degree.
Okay, help me out here. So, DNA identification, used in courts originally in the 90s. New York was the first state to use DNA to either convict somebody or exonerate somebody. But I think it was to match up a suspect. But the amount of DNA, the amount of material you needed compared to today was a lot more, correct?
Correct, because the techniques and technology many years ago meant that you required a lot of starting material known as template DNA, because the techniques weren't as sensitive. The enzymes that we used, the primers that we used in the analysis, they weren't as elegantly constructed as they are now. Today, with the techniques, they're much more sensitive, which means that you require a very small amount of DNA as a template to achieve a successful PCR. Back many years ago, you required much more material. That isn't the case today.
Right, and so there in the 90s, they started to learn about this, and they'd submit something for testing to try and exonerate, but there wasn't enough. And then hopefully, it didn't get consumed. But then fast forward, and that you had amplification. And now, is that PCR amplification, or is that okay?
No,
So they developed the PCR technique that you were talking about, and so that would be an example about new evidence. It can also be a new scientific technique that, hey, we're now testing stuff even smaller than that, and we can get a result. So they could file a motion with the court and say, we have new evidence or new testing that we can use. And even though they brought a 97406 motion when they had the pre-PCR, but I was thinking of you the other day when I saw that question. That's one quick example. And then, of course, we've got a couple of others that I'm not nearly as familiar with, like MVAC and rapid DNA, the bones, the burn bones. Yep. So, yeah, the answer to that is you can effectively unbar evidence or make evidence that was rendered irrelevant by a, thank you, Dr. Silkman.
No worries.
A barred, procedurally barred issue. You can make it relevant again with new evidence. Do I know Michael Caccini? And I don't know him, but I know of him. He's excellent attorney. He's well written. His books are excellent. He's accomplished in post-conviction, but there's even there's another guru in Wisconsin that there's a tremendous amount of post-conviction. He's got over 100 reported cases, and I use him as a resource, the writings and things he's done. But I don't know Michael personally, but I know of him, and based on what I know, I have the highest regard. Alice, do you have any yet? We'll answer a couple of those.
Hey, Travis, if you can, who's this resource, or do you not want to say? And if you don't, it's fine. This other lawyer that you confirm.
Let's see. He may be at the bottom of that paper, or I may have cut him off. I'll get you. I don't want to botch his name. I'm terrible with names.
That's fine.
I got Silkman and Jack, and I can handle those, but it gets tougher and tougher as I go along.
I understand. Alice, any questions from chat that maybe we can throw in here?
Yeah, we've had a few. We had one for Grammy, which was, is there some sort of law that oversees the amount of time a judge has to consider a motion? So we kind of went over that one. TTM Fangirl, she says, can we show the judge was ineffective?
The judge. Well, I think we have in our commentary these last 5-6 years, but no, the way you show a judge is ineffective. The statute, what it was designed, the Supreme Court rule, this rule of administration, we're talking about a judge that had 300 cases and none of them were being ruled on, and they were trying to come up with a way that they could put in measures that things didn't slip through the cracks like that again. They had checks and balances. So they required all the judges to put list old cases. And, I don't know what the numbers are, but there's no way that if you're a busy judge, some of your cases don't creep over 90. If it's 60, it's going to even be more. But, I think the way that system works is that you report them, and then what they're really looking at is month over month. That, you have 12 that are over 90 last month, you have 6 this month. They're not going to do anything. They're looking at trends. And then if you were down a week or 2 weeks with something else, that triggers an automatic another 90. But but in terms of her decisions and whatnot, being ineffective, the way you handle that, as with any judge, is you take it up the line to the next court. That's all I got on that one, I think.
Just quickly, Trav, if you don't mind, Trav, because the next category on our question list is ineffective counsel. Because you've just come off that with a judge, maybe you should slip in the next part of that, because it's all about the questions from ineffective counsel that we have listed next. Because a lot of the questions that are coming in, I've realized they're actually in the categories in this list that is coming through. It's just worded differently.
If that's the case, Cal, point that out to me and just say, hey, this is, because if I can answer 2 for 1, I try and do the same thing Dr. Silkman does in the lab. I try and not get 2 results for every test I run.
I have been updating it.
That's what I was doing. Questions that I thought had already been answered, like Grammys about the motion. We've already been over that, so that's why I missed that question. So I'm trying to get to ones that people have put in.
You're doing wonderfully, thank you. And I can understand every word you say. I don't care what anybody says.
Oh, thank you, Travis.
I'm a little offended you're not swearing, but I guess it's just me.
Well, I could
add Put the warning up. Put the warning up.
All right, Travis, if I could just make a comment. Previously, you were talking about the new DNA techniques that can be potentially used today. I've read legal arguments preventing Kathleen Zellner by utilizing the techniques of today, because the argument is that they're not fit for forensic purposes. So PCR is a recognized technique that's used throughout the world. Every laboratory does it. But new techniques like the rapid anti-DNA system, as well as the MVAC, there have been arguments put forward that they're not fit for forensic use. So even though this is very frustrating, so even though there are new, more sensitive techniques, there's been arguments that Zellner cannot utilize them because they haven't been officially been sanctioned or AOK'd by the FBI and other authorities to allow the use of those techniques in a legal sense. Do you know what I'm trying to say there, Travis?
Oh,
So even
absolutely,
though
absolutely.
so this is very frustrating.
So it's been that motion is actually what prompted me. I believe it was December 18th of 2016. Is that when MAM 2 came out, or 2017? Anyway, December 17th, they filed that motion and they listed the bones they wanted to do rapid DNA on. And I was going through those, and it popped out at me that those bones, because of another thing we were doing on Eric Hosey's channel, unrelated, about bones, the last 2 pages of CASO at the time talked about the return of those bones, and we also had ledgers, and all of those bones were returned to the family. And so I did a thing with Eric Jose that very night about spoliation of evidence, and that this would have, could have a tremendous impact. And so I kind of lost focus on that rapid DNA being able to identify, all of the bones from that horrible fire in California, the Paradise Fire. But that was talked about in the court's ruling. It was one of the 7 motions. And I'm going to go back and look at that, because that was one prong they were looking at. But my recollection was they ultimately, this is completely baffling to me. They said it was okay to deny the motion for rapid DNA testing because the fact that those could have been human bones off property was irrelevant, didn't tend to show anything with regard to Stephen's guilt or innocence. In other words, they said, we don't need to determine if this is Brady because they're not exculpatory, because it doesn't tend to show, just it left me gobsmacked.
Well, the argument being that they made was the fact that the individuals that took the bones out were not forensic anthropologists. So the argument is, well, how do you know that the Hallbucks received human bones? And I sort of fell to the floor thinking, wait a minute. So the Hallbuck family is now going to accept potentially animal bones as a or bones from another victim as being representative of their daughter. And it seems like they're being so recalcitrant in their approach. And I remember the judge making an argument, well, even if those bones ended up being Teresa Hallbuck, so what? How can you prove that your client didn't bring those bones to either Cuss Road or the Manitowoc County gravel pit? And it's sort of like very counterintuitive that on the one hand, Kathleen Zellner, through her experts, are finding all this incredible new evidence, and the courts are shooting down everything, including Ida Merfell, the bullet. So it leaves Stephen in a very delicate situation, also with Kathleen Zellner, because their legal arguments are completely baffling, in my opinion.
No, it's, I understand where you're coming from, and I have sections to explain, which is a different word than justify their judgments. But on the issue of, I don't, my recollection is they just shot it down logically that they said, you haven't shown us enough that you're required to do under 97406. Not that it was, you haven't shown that this is a valid scientific test, but I may be wrong on that.
Well, the argument was that Andy wasn't fit for purpose from a forensic standpoint. And the thing about we mustn't forget, no bones have been forensically tested for the extraction of genomic DNA or mitochondrial DNA. My understanding is the only genomic DNA that's been extracted was from a muscle tissue, right? So what Kratz was trying to present in court was that the muscle and the bone are related. We
So
haven't,
the
state hasn't proven that.
Yeah, the Court of Appeals was pretty crafty about that. And that, this is probably what you're talking about right now, the 7 issues or thereabouts that they did reach on their merits. I have a section on, we should probably do an entire show or segment on just those 7. Dr.
Oh, that'll be
Silkman,
awesome.
and talk
That'll
about
be awesome.
That, let's take a look at what they're looking at, because it's blood spatter. So the issues were 3, ineffective assistance of counsel, but by not obtaining a blood spatter expert. And then number 2, not obtaining a DNA expert to explain why FL was compromised and why the key was planted. So again, not to justify, but I think it's really worth us doing another segment on it specifically so people can try to understand. Whoever wrote the brief, Kathleen signed it and the local counsel did, so it's ultimately her responsible. But there's 3 or 4 mentions in there that she misrepresented in her brief what the experts were saying, the actual affidavits that were attached, and that can put a court off pretty quickly. Now, one of the things I know that they said on FL, that they said, I don't think they called it a misrepresentation, but what they said is that the state never argued that FL was fired into Teresa Halbach's head, skull. And, I'm familiar with what Kratz argued in his opening statement, and I know exactly what he said, word for word. And I know exactly what he said in closing argument. And their decision, the rationale that they had in the opinion, I just thought was bonkers. However, on some of the others, it could have been listed out more specifically, but it's a difficult thing. I forgot about that. They did the old warranty for fitness for a particular purpose trick, but every instrument, every medical or scientific instrument comes with a booklet and a manual. And at least in the United States, they disclaim warranty fitness for a particular purpose. Has nothing to do with the accuracy or the validity or the repeatability of the instrument. It's just, that's what you put in any expensive equipment that you sell, because you don't want to be liable for something that there's no way for you to foresee because somebody didn't perform the test properly. And anyway, no, I understand the feelings on that, but frustrating, no doubt.
Yeah, each technique has to be certified. So it's got to be agreed upon that it's going to be a technique that can be used for forensic analysis, that it can be submitted to the courts, and everyone's happy with it. Because Kathleen Zona eventually used DNA methylation to look at the blood that was in the RAV4. Now, DNA methylation is not a routine technique like PCR is. With PCR, someone in high school can actually do the technique. It's that simple and straightforward. Whereas something like DNA methylation, you require a specialized laboratory, highly skilled operators, and you need to be able to interpret the results. The courts were arguing that a simple thing like ANDI, with rapid DNA system, which is fully automated, and also MVAC, because it's potentially a sophisticated process. Their argument is that no, you can't use those techniques because you can't submit them. So they're essentially cutting the knees off Stephen Avery and also Kathleen Zona by saying, look, we have this evidence, we have the means to test it in a deeper fashion. The courts are trying to deny Kathleen Zona from doing that.
All right. Well, Travis, I'll let you take it to where you want to go. Where you want to go? You want to stay on the questions list here?
Let me knock out a few more questions, and
Yep.
I have all of the issues that we've talked about so far about doing a deeper dive. We can go back and look at, including the that motion, the denial of the motion. She got remanded about the return of the bones. So ineffective IAC is the test for post-conviction IAC and trial attorney IAC the same? That's an excellent question, and we kind of talked about that at the top a little bit. So when we're talking about post-conviction, the time in between the sentencing date and the appeal, like that Stephen had the evidentiary hearing on IAC and Denny, that test for post-conviction counsel, if you want to contest that, you would file that in the circuit court, and it is Strickland. And then for an appeal, that's where it's a little bit different in Wisconsin. If you're claiming that your attorney on your direct appeal, which Kathleen, I think, did at one point, or maybe Stephen did, you need to file a separate writ in, it's called a Knight motion, K-N-I-G-H-T motion in Wisconsin. You need to file that in the appeals court. Wisconsin felt that it was better for appeal judges and courts to determine whether appeal counsel is effective or not. And it's best for trial courts to determine whether hearings in their courts, the attorneys are effective or not. And then the standard on that so here's the irony. It's Strickland plus they added this other requirement on top of what already was in Strickland in a case back in 97, I believe it was. They said, yeah, it needs to be Strickland plus you need to show even more the materiality. You need to show even a higher bar that the outcome would have been different. And that case, ironically, was Stevens' appeal. And it took 15 years for them to realize that this extra requirement that they had for IAC for appellate attorneys was just unfair and unconscionable. And my go-to resource attorney wrote extensively about that, and I learned a great deal from him on that issue. And then 97406 counsel, since you're not entitled to them, you're not required to have them, and it's a civil case by nature, according to section 97406, says specifically it's a civil in nature. You have no claims for ineffective assistance of counsel of your 97406 attorney. So bad news there. That's different in other states like Texas, which provide you an attorney on a death penalty case. And the collateral attack statute, like 97406, they appoint you an attorney for that. Because they do, they have to appoint you an effective one. But since Wisconsin, they don't have the death penalty. No, nothing. If SA was to fire KZ and obtain a new post-conviction lawyer, would they file against KZ for dismissing the pro se motion as IAC? No, because there's no IAC for 97406 counsel. 3, if he was successful in IAC on KZ, which it can't be, would that automatically bring back all the areas, evidence in the case that was procedurally barred under KC? That can't happen, but if KC wins on an issue, winning meaning that she had got to finally have an evidentiary hearing, so for example, she was granted new testing on FL or the key fob or the bones particularly, it doesn't look very likely at this stage, but if she was able to do that, it would make those items relevant again. And so she would be able to bring those specific things in, like the bones or the key fob or FL. And then if she was granted a new trial, everything resets from the beginning. Everybody understand that what I mean by reset? If she was granted a new trial, if Stephen was granted a new trial,
all the evidence she could use, right?
That's correct. Everything resets, and she could pursue everything. The fact that something got ruled on as being barred there would be no bar in a new criminal trial. Anything that's relevant and admissible in the trial would be admissible and relevant regardless of what was determined about it on appeal, either in 97406 or direct appeal. I'm going to do another one unless Alice or Kelly have something. Brendan versus Stephen evidence. The evidence that has been procedurally barred against Stephen Avery, is it now also barred against Brendan? No, absolutely not. Brendan has, he had a direct appeal lost and then went federal habeas, and I'm not going to rehash that tortured escapade, but so he has not filed a 97406. So he can file a 97406 anytime he would like. He would be procedurally barred on anything that he could have brought in his original direct appeal. So he did go after IAC on his original attorney and that private investigator. They both testified in the evidentiary hearing with Judge Fox. Wouldn't be able to relitigate that. But I wanted to answer this question because there's a big distinction between Stevens and Brendan's case. One thing for sure he would not be able to litigate is the legality of the confession. So he's got a legal confession that he has to contend with, which means about the only way that scientific forensic evidence is going to help him is if it showed what we call actual innocence. And that's, people that wonder why haven't they filed, or what are they doing? Can this help Brendan? Now, if Stephen ended up getting exonerated with, in combination of scientific forensic evidence and possibly witnesses to events immediately before or after the time of the murder was supposed to have taken place, then you'd kind of have an equitable issue that the person who's the main perpetrator has been exonerated, but his accomplice, for all intents and purposes, is still locked up because of the questionable confession, which is, under the eyes of the law, is a perfectly good confession. It's never going to change. And so that might make some scientific evidence enough to get him out on a actual innocence claim. But that's why his case is tremendously different, and that the scientific evidence is not going to be as helpful, if at all, to him, because it's got to show actual innocence, and even
really high bar.
Yeah, someone else had a question here. Good question. I'll go ahead and answer this one. It's on page 2 towards the bottom, book, legal publications, recommendations. Can you recommend a book or any legal literature that the community can learn more about the post-conviction process under Wisconsin law? If you haven't read Jerry Buting's book, I highly recommend that, because he talks about in detail his exoneration of Ralph Armstrong. And many, many of these issues that we're talking about for Stephen and Brendan, this was a murder that happened in an apartment. DNA found on a bathrobe, and their person who's convicted, they start doing DNA testing, and it's not him. They find DNA. It's neither the defendants or the murdered girl's boyfriend. It's a third person, and Barry Scheck calls him up and asks if he'll be the local counsel for this case, and he does. Thinks it's going to be about a year long, and it ends up taking 10 or 15 years for Jerry Buting to get him out. But I highly recommend that book. It's real easy read for lay people. That
it's a really good book.
He finally proved that the prosecutor in that case destroyed evidence, and on purpose. He got the Seventh Circuit Court of Appeals, the federal court, said exactly that. That's the court that Brendan got his case. He won, and then the Embach hearing, it went the other way. But got the state courts to say that this prosecutor was guilty of prosecutorial misconduct, and it was quite a journey. But I think everybody could learn more about the post-conviction process and how some of these prosecutors can, fight for the longest time just to preserve whatever it is and they have in their head that they think they're fighting for. But and it's a very even-keeled book. And then, of course, he talks about this case a lot. But so that's one for lay people. And I'm going to get the name of my guy here in a minute. But did Alice or Kelly, do you have any more?
Yeah, Crockett Thompson in chat. He's there. Why does Willis get to rule on an appeal? Is that not a conflict? It should be.
Okay, say that one more time.
Why does Willis?
Judge Willis what?
Why does he get to rule on the appeal? Is that not a conflict of interest?
That's a good question. So Judge Willis and Judge Fox ruled in the post-conviction motions. They both ruled on the issues. And so, yeah, to some or many, you got the trial court judge, and he's ruling on whether the person, it was ineffective assistance of counsel, whether, it was proper denny, whether, and it's like, they've already ruled against. Why on earth, do they get to rule on it again? And the theory behind it is that we want to give the trial court judge an opportunity to fix his mistakes. So the good thing about it is if you can show the court, because you have more information, you have more time to brief it, you can call witnesses after the sentencing, you call these witnesses, you show and you say, hey, look, we understand why you ruled and how you ruled during the trial or pre-trial, but we think, we've showed that with all this new information, the decision should have been this way. If the judge goes that way, then the state can't appeal it. You get a new trial. So they're given the court the last opportunity to fix their own mistakes. Obviously, the other side of that is that, well, they rule, they get to judge themselves in a manner of speaking. They're never going to find that they erred, but, I've seen many times that they have. So to counteract that, you've preserved those issues when they go up on the direct appeal to the Court of Appeals and you have a 3-judge panel. They get to look at all of the information that was developed and they review it de novo, which means brand new. And they look at it one more time to see if what the trial court judge determined. But Crockett, that's a concern a lot of people have, and they're surprised about when they become involved in a case or follow a case and learn that, wait a minute, the trial judge who made all of these rulings, he's going to rule again, and it's disheartening or shocking to a lot of people. But so to answer the question, no, that's the way we do it in the U.S. We give them a chance to fix it, and then if they don't, and you have to bring those motions for new trial on those things that need evidence developed, like a new evidence motion, ineffective assistance of counsel. They did it on the Denny for Stephen, because if you don't, you waive those on direct appeal, because the appellate courts don't do any fact finding. They won't, you can't submit affidavits from Jerry Buting or Dean Strang that they might have been ineffective. So you have to do it in those hearings before you go up on appeal. That was a great question.
Yeah,
Trav.
I mean, that was that. On you go, Cal.
Oh no, you finish off what you were going to say. I was clearly.
I was I was just going to say. I mean, that was one of the things. With me being an outsider looking in, that was one of the things that was completely weird and off the charts to me, was the fact that the same judge that sentenced you is the same judge that looks over your appeal. Because if they made a mistake the first time, they're not going to admit to making a mistake the second time. So how is that fair on the defendant? So that really blew my mind when I seen that and heard that.
Yeah, and so hopefully I've understood, and these terms, they're hard to keep straight, but so you have this sentence, and then you are appealing. You're filing a motion saying that your trial attorney was ineffective, and then the trial judge is going to determine that. And so, we frequently call that appeal, but if you remember that that's a post-disposition motion, and then you still have the full right to appeal, no matter what Judge Fox determines, no matter what Judge Willis determines. You have to go through that hoop, and then if they don't rule in your favor, you still have the recourse for the full appeal, the direct appeal. It's automatic. You get a 3-judge panel, not only to review what happened in the trial, but what Judge Willis did on the motion for new trial, or what Judge Fox did on the motion for new trial. And actually, you get an automatic evidentiary hearing. And so, the good post-conviction attorneys, they're setting stuff up to give them a better shot at appeal,
and they normally would. They in other words, they know that they're going to lose the motion, but they're not really doing it for that. They're doing it to get some good evidence that'll be part of the official record when it does go to an official appeal. But yeah, it's the first step in an appeal, and it's disconcerting that the trial judge, that may be your best shot, this post-conviction motion about a month after your sentence. That may be the best shot you ever have, and the trial judge is going to be deciding it. But yeah, that's the process. But I certainly understand. But hopefully, putting it into context that you still have a full appeal after that automatic softens that a little bit.
I was just going to say, Travis, because you touched base on the ineffective counsel, or my apology, you were comparing the Brendan case and where he's at now. I've been going through our list, and you have answered a lot of the questions within the questions. So if you want to maybe go back to the Brendan case list, you've only actually got 2 of them left because you've already answered majority of them, and that's point 3 and point 5. Point 3 is, if you were Brendan's lawyer, what would you do next? And the other one was, how can the community find out if Laura has ever tried to get the RAV since KZ can't? And then I was just going to suggest to you, because I'm seeing a lot of Denny questions starting to pop up, maybe we could go to that list next, because you haven't touched any of those questions we've got on the list hasn't been touched yet, and they're starting to roll in.
Oh, sure. Okay, so Brendan's case, which numbers?
Go to number 3 and number 5. You've answered 1, 2, and 4 throughout this, without this whole conversation. So hopefully, the way you've done it, everyone would have understood these anyway, because you answered the question within this question. So point 3 and 5.
Lawyer, I'd never be Brendan's lawyer. He's got 2 of the smartest in that field. And if I was his lawyer, I'd be calling up Laura and Steve, asking them what I should do next. What should they do next? I'm not even qualified to judge what they should be doing. I suspect probably nothing, because if you file a 97406, and they mentioned this a few times in Stephen's opinion on Zellner's 97406, is that she decided to file the motion, and they used the term unreservedly, meaning she could have put in her motion, look, we're doing this now, but we're developing some things, and we reserve the right to supplement later. Didn't do that, and 97406 is supposed to be one time, or because you have to show a good reason why it wasn't brought in your original appeal. And then, if you file a second 97406, you got to show a good reason why you didn't raise it at trial, and then why you didn't raise it in the motions, post-conviction motion, why you didn't raise it in the direct appeal, why you didn't raise it in the first 97406, and they can shoot you down, if you could have filed it earlier on anyone. I don't think there's really anything for them to do until hopefully there's a big break with Stephen's case. And unfortunately, that didn't happen on the scientific side. There's still, and this is another section I have, they've left some things open for her. One was what's pending now. They've left open a couple of other things that she said she could file in a 97406, but Brendan really cannot risk filing a 97406 unless he's got something tremendously solid.
Basically,
and I don't think there's any.
Basically has to be new, right, Travis? Something new that wasn't known prior.
Yeah, because look, what do we have on him? So we're stuck with this confession that's deemed legal and non-coerced. So that's the bar. He's got to have an actual innocence bar, which is high. It's like, there are some actual innocence cases that have been done with non-DNA witnesses recanting or things happening, but those are extremely rare. It's, their actual innocence is typically DNA, and DNA that is definitive. And, Dr. Silkman would know way more about this, but, DNA being here or being there, sometimes doesn't prove anything on guilt or innocence. And sometimes it absolutely does. It just depends on the context of it. And so what do we have forensically on Brendan? We have that there's nothing, right? There's nothing that
no,
zero.
And there should have been. There should have been on his shoes or his clothes or at a minimum bleach stains. So when you look at it in that context, it's just totally in a 180 from Stevens, where the right piece of forensics, somebody coming forward and saying, I can't live with myself anymore, or whatever it is, take a combination of things. But Brendan's situation is he's legally confessed and there's no forensics. And so let's say they did something with the prints, or they did that they were finally able to do something with palm print or
A23, the blood on the back door of the
blood on the back door. And let's say that comes up, nobody in the family, the hatchet guy. What's the hatchet guy's name?
Andres Martinez.
Comes back to him. So logically, doesn't that mean Brendan is not involved? I mean, but see, it would totally undermine his confession, right? Clearly. Yes. But under the eyes of the law, that wouldn't undermine it. So it's got to be showing. But if that was enough, the palm print, the blood, was enough to establish that he was the perpetrator, and that it wasn't, they're going to argue, it was Stephen and him. That doesn't prove that Stephen didn't do anything. And
the unidentified co-conspirator.
Yeah, read Buting's book, and what they put that guy through when they kept coming back with hey, this DNA is this, and well, that's not, I'm just crazy crap. And, I'm not super encouraged. There's a case, 3 African-American teens, 18, 19, 20, went from a rural area of Wisconsin to Madison, and they went to, I think, kind of work selling magazines or something. I may have that wrong, but they end up meeting some kids the same age at University of Wisconsin, and they drinking, and one of them ends up having sex with one of the university co-eds, and all 3 of them end up with a sexual assault or sexual assault related accessory offense conviction. 2 of them hired 974, their own 97406 attorneys, and got exonerated. The third couldn't afford one, and everything applied the same to those 2 as the one, and it just didn't bother them that he, stuck with the conviction. And there's just some crazy stuff. I mean, there's examples of this stuff in every state, but it's obviously there are a lot of people, myself included, that every time there's something significant that happens in Stephen's case, I'm always asking myself, what's the impact for Brendan, right? I mean, I think we all do that. And,
Absolutely.
And I wish I had more to say, and I wish I could paint a better picture. Obviously, if Stephen got exonerated and through some sort of use of forensic evidence coupled with whatever else, even if it's to help him get an excommunication or pardon, whatever it might be, I have to think it would help to some extent, but law is based on all these logical principles and logical analysis, and I've got a whole section on that we can look at. That part of the problems in Kathleen's briefs was she was using conclusory arguments. She was basically letting the affidavits argue for themselves, and that got pointed out. That they said, these things are self-identifying, but you've got to, and they cite the case. You got to do the who, what, when, where, why, and how, and you got to lay it all out. And so, for example, the experiment with holding the key. They point out that, that would be favorable for him, and would favor his argument about no planting. I mean, that it was planted. But that's not the standard in a 97406. Evidence that would have been helpful for you at trial in the standard, you've got to show it would make a difference. And they're saying so, and they're using just straight logical analysis. That 15 people touched it, and 4 left DNA, and a minuscule quantity of, but they're saying you have nothing there. The expert doesn't say that couldn't have happened. Now I understand what a good scientist, what a reputable scientist, a credible scientist, he's going to say what he can say. And, and then for the court to turn that, you're not going to get any scientist to say, I could say to a reasonable degree of medical certainty that it was planted. That was, one of the other things that they were dinging on. We really should do a whole segment on that, the 7 that they did decide on, but they were over and over and over. And, I think that's important for people to understand. So all of the good and hard work that you all do on, educating people about DNA going way, way, way back when with Dr. Silkman, and then all of the freedom of information requests and getting all of this information to try and assist in connecting dots. And so that's awesome, and that's great. But then to take that to the next level, it's got to be laser focused, clear jumps, A to B, and there can't even really be any jumps. I mean, it's just got to be
direct
linear, linear. Right. And I want people to understand the difference. There's a difference in researching and helping to put together, and researchers, including this group, have come up with things that have helped on arguments with Kathleen. I'm sure of it. I know of at least one, and but it's in case people wonder, well, why isn't she using this in a brief, or why isn't she using that? And when we do a longer segment, hopefully on these other things, I'll point out where they said, she was misrepresenting her experts, and maybe we can dig in a little bit at that ourselves and see what we think. And then, she's already on notice from the court that they said it's becoming a pattern of misleading. We'll look at what the actual wording of the affidavit says, and we'll look at her wording in her brief, and then we all speak English, except Jerome from France, but anyway, and we can look for ourselves, but I do want people to understand that you're in this appellate court. There's somebody on the other side who's going to have an answer, and so you got to anticipate it. And then judges do what judges do. They judge who's credible. They judge who's accurate on the facts. They judge who's accurate about their description of what a case holds. That's one of the strongest things you have, being a trial lawyer. One of the biggest assets I have is my credibility. And you start compromising your credibility and your integrity to maybe help one client, you've compromised it for every client you have since then. I mean, I'm not talking about divulging attorney-client, or you advocate very zealously on behalf of every client, but you need to be extremely careful that you don't compromise. Dr. Silkman he deals with certified equipment, certified testing, proficiencies. We have a lab in Houston. They were faking the proficiency test. They had to shut that lab down for 3 years, recertify it. with just one person they were helping with on efficiency, but these labs, all they have is their integrity. I'm not talking about crime labs. I'm talking about academic and research laboratories. It's critical. Wouldn't you say, Dr. Silkman?
100%. But just on what you were saying, Travis, that's why crime laboratories have to be held to a higher standard. All laboratories have to have their own protocols and internal standards. But a crime laboratory, especially one involved in producing evidence that can be placed in front of a judge and a jury, has to be 100% correct. You can't sort of second guess. And that's why it was extremely infuriating for me seeing the type of material that was being brought forward in front of a judge. For example, item FL and all the shenanigans that went around that. And the fact that Norm Garn, who's meant to have knowledge in science, and the mere fact that he wanted to allow an exemption for presenting item FL in court based on the fact that Culhane had contaminated the PCR negative control, really goes against all scientific ethos and common sense and practice. Now, if you try a stunt like that in a research laboratory, you'll be thrown out of the lab, right? The mere fact that they were able to present item FL in court and the judge allowed it goes to show how low the bar has been set for this type of forensic evidence. The fact that Buting and Strang had argued that they wanted to be present in the laboratory to witness what was happening, and the state argued that no, you can't because of fear of contamination, and yet one of the most crucial samples that nailed Stephen, item FL, as being the instrument of death of Teresa Halbach, item FL, which held the story together for Brendan, right? You got to understand how important item FL was.
Hell yeah.
Because it gave a legitimacy to what Brendan was telling them, Fassbender and Uyghur. The mere fact that item FL got accepted as evidence goes to show how dishonest and disingenuous the entire system is. And my final point is this: there's no test for planting. So that's the issue. There's no test for planting. And you made a really good point, Travis, because Kathleen Zellner did the experiments regarding the key, right? And also the hood latch. Now, even though the DNA samples that the state got were totally inconsistent, the judge will say, well, it's his DNA. Okay, the levels aren't what you expect, but DNA is DNA. So the argument is, it's Stephen's DNA. He touched the hood latch. He touched the key. End of story.
Yeah. So yeah, number one, I think if you haven't read his book, you need to, Dr. Silkman, because
I've got it. I've read about half of it. It's brilliant.
Because he talks in there about the exoneration. He started getting court orders, which they granted on that case, because he was suspecting that the DA was orchestrating these things on tests, and it turned out he was. And so how he destroyed evidence is he got the detective. There was an order that anything that was to be tested, he had to inform Jerry Buting on, and Jerry Buting or his experts needed to be able to witness it. Well, he totally ignored the judge's order, had the detective take the tie on a bathrobe, the part that ties, and he was slick enough that he knew that it was going to fully consume the sample, and it did. And and it was equivocal. You know, it was only 6 of whatever locations. But so they couldn't exclude his client. So, I mean, it was just terrible. But, you know, I've advocated that crime labs, even though in the United States we have a CLIA as the certifying organization, but that doesn't help with all of these nefarious things that continue to happen in the labs and in Texas. But I've always thought that they should be out from under law enforcement.
Absolutely.
They should a separate, like in Colorado, it's the Department of Weights and Measures, believe it or not. But totally out from under law enforcement. There's no notes or phone calls saying, I need to put him in the garage or the house.
Or the trailer, you're correct. But also, sorry, Travis, but here, this is a clear example of a massive conflict of interest in Cherie Culhane putting her hand up to be the lead analyst in this case. For example, she knew exactly where the swabs had come from, right? So she can control in the laboratory any outcome that she wants because no one is supervising her. She's got the samples. She had Stephen's genomic DNA from 2003. Look, listen, I've worked in a lab for many, many years. You're dealing with test tubes, small little tubes in an ice bucket. No one's looking over your shoulder. All you have to do is swap a label or put a pipette tip in the wrong tube, and you can have any outcome you want. That's the danger when the analyst knows who the person is. That's the potential suspect, and the analyst knows exactly where the samples come from. Cherie Culhane had total control of all the samples, the forensic samples, and she could easily control the outcome. And as Jack pointed out, right, Fassbender rings her up and states, try to put her in his garage or house. If I was a judge, I would have thrown out all evidence and got it retested independently.
Yeah, you know, that's right. And you know, I got a comment, and I also have a question for Travis about, because I've wondered about this for a long time, and maybe you can answer. First, number one, I think so many people are frustrated with Brendan's case because we have this, I think everybody feels it was a coerced confession over many days or whatever. But number two, there's nothing forensically to back it up. Nothing. Second part, Travis, is they go after Brendan and they get this so-called confession. From that, they immediately get search warrants from all of this, from March 1st and 2nd, and voila, they found this bullet, item FL, that Doc's been talking about. Well, that bullet gets dragged into Stephen's trial, yet they separated Brendan and Stephen independently, a week or 10 days before trial at all, but they still used that bullet in Stephen's trial from information they got from Brendan. You see what I'm saying here? I just have a question of the legality of that whole thing, because it just seems to me like they just pulled a big fast one. That's the way I look at it.
Well, the evidence doesn't follow the defendant. If the evidence is legally obtained against one co-defendant, it's available against another. So it's assuming it's legal and so on. There's nothing you can really do about that.
That's what I'm saying. They separated them prior to Stephen's trial. They couldn't even mention Brendan at all.
Who couldn't?
Well, I think
The
it was
state?
Gone that I think it was Gone that brought it up in some pretrial motion that they should remove Brendan's name from everything. As far as I know, he wasn't really brought up at all in Stephen's trial. Now, in Brendan's trial, it was actually another mini Avery trial, but it wasn't that way in Stephen's trial.
Stephen normally, under normal circumstances, would not want Brendan mentioned at all because of the confession. Now, funny you should mention that. Jerry talks about this in his book. They had that press conference, which was totally unethical.
Oh, yeah.
And so everybody hears about it. They're able to move it out of Manitowoc over to Calumet, but it's still Manitowoc jurors, just no Manitowoc Sheriff's Office. And you know, that's just one of those strategy things. He's trying to, at first they were trying to get out that Stephen was exonerated. Well, and the judge ruled on that pretrial, but they were able to bust that door wide open. You saw that in the cross-examination of Colburn. You know, have you ever had your integrity questioned before? No, I have not. Well, this isn't the first time that I can't remember it, and I can't even paraphrase it to give it justice, but Dean's so wonderful with the English language. He goes, this isn't the first time Stephen Avery's been falsely accused. So let's start sticking to the facts. Remember that? So, I mean, yep. But, you know, we're kind of far afield on appeals, but, you know, appeals unfortunately can't fix, at this stage, the trial court letting that stuff in. Now, in a perfect world, you know, we would have had people with Dr. Silkman's credentials and insight and what was happening, and then in a more perfect world, even if that wasn't available, the state defender's office has more resources for experts. They could have brought in experts on the IAC claims, could have brought in all of those claims and got the judge to see, hey, look, this is why you should not have let that in. That DNA isn't DNA. That, you know, they're pulling the wool over your eyes. Exactly what he said. But that's how you would perfect that on appeal. And you know, that's the thing with our system, that we have these presumably these safeguards and standards on forensic science and experts, but unless you have the resources to combat that, and just to pay a DNA expert to sit through the entire trial. You're not going to testify, which means the other side can't call them. I just need you to tell me stuff I need to cross with. That's the unfortunate thing. And so I don't have an answer on, how you fix that. The best way to fix it is to have the experts to go to, which almost nobody can do unless you're OJ, and then
that's true.
And then barring that the defender service on the appeal
has resources to bring in people. Yeah, it's tough, but in terms of an appeal, that's those motions for new trial. That's where you get it at. And I know of at least 4 exonerations on shaken baby syndrome cases, and the science on that changed. It changed with the ER doctors that would testify that this, had to come from that, from the coroner, pathologist, the science. There were indications that the science said at the time, yeah, this is shaken baby syndrome. These are the telltale signs. And then over time, it was discovered or determined that they're not specific. They're not specific for anything. And those people got exonerated. We're talking 14, 15, 16-year-old babysitters.
Right.
And science and forensics, it's a big thing. Jerry Buting's exoneration, part of how they didn't find any DNA, but they found some hairs. And here we go. 3 hairs. Well, they're consistent with, and then the closing argument is, we got a match. We got a match. And, all of those problems. And unfortunately, because the doctrine of finality, and our interest in having finality, because tough on crime started in the 66 election cycle. A little earlier in state, 64. And it's been run on hard in the United States ever since. And there had been a long, long push for what became EDPA, but reform of writ of habeas corpus. As a matter of fact, it was the states did it well before EDPA came in. And Wisconsin's reform statute came from the American Law Institute, came up with a model statute on like 97406 on these collateral attack writs. And they adopted theirs originally in 1966. And they changed it to essentially, you get one shot and on a collateral attack, and you got to show a good reason why you didn't bring it in a direct appeal. And then if you get past that, you need to bring everything in one motion. And the rationale for that was, we want finality. Because before then, some states that didn't adopt that reform, it was successive motions, and those were the stories where you heard about victims' families waiting 10, 20 years before there was a final resolution and running out of appeals. And so we have a tendency in the U.S., probably every democracy, that we tend to throw the baby out with the bathwater. We tend to make radical swings during wartime, and we made a lot of progress in the 60s. But in the United States, you weren't even entitled to an attorney until Gideon, which was 65, I think. Can you imagine? I mean, you could be tried for the the death penalty in all these states, and you didn't need a lawyer.
Yeah, right. I think Edfield
Yeah.
went too far.
Yeah. I've got a question for you, Travis, and it's actually me and Crockett in chat. I noticed he posted it a wee while ago. Brendan recanted. He basically recanted and says they got into my head as soon as Barb went into the room, and they can fly in that room to stop him from saying anything else. He also recanted the confessions and that before trial. And then that Wayne had the balls to get on the stand and recant everything that he said after Uyghur and that tried to make him out to be this, monster. And he had the balls to get up there and say, no, it was all lies. I only said what they wanted me to say. Why does that not go as a dismissal for the confessions that Brendan made? Because he was recanting, is that always something that happens? Because if he's lying now, because you would think if he's saying nothing happened then it's something's happened in that interrogation room. Do you know what I mean?
Yeah, I understand. Why, if somebody confesses and then recants, why is the confession still valid? And again, tough on crime, and the judges who are elected, which is most of the states, versus appointed in the federal, which is why it was important to have federal habeas. Jack, you're right. It did go too far. It emasculated the federal judges who don't have to worry about being reelected every time. When a super popular kid in a community is murdered, and there's no way you're going to be reelected if you are looking as being overly favorable to a defendant. Some elected judges still are, and sometimes it costs them. But that was the great safeguard of the federal system, is they could overlook anything. They didn't have to give deference like they do now. It doesn't have to be clearly incorrect like it has to be now. And so the tough on crime attitudes, they said, well, it's not going to be unusual for somebody who confesses, understanding what they're now facing, to change their mind. But I'm not aware of any state that renders a confession inadmissible or determined to be coerced inadmissible simply because of recantation. You got to show it was coerced. Unfortunately, in Wisconsin and the Seventh Circuit, that means a demonstration of the breaking of the will. When that's not going to manifest itself with people like Brendan and others. But
I mean,
hope I answered that.
They didn't show that. They didn't.
Perfect.
Alice, they didn't show that part to the jury.
No, they didn't show they got into my head part for the jury.
No.
That part. Well, again, if you haven't read Buting's book, he talks a lot about his feelings when he learned that the last 20 minutes of that confession, so-called, weren't played to the jury. But it's strategy, so you can't appeal it. You can't say it's ineffective assistance of counsel. He also talks about that he had the Dr. White report and offered that they were gonna pay to fly Dr. White down.
That's right. I just don't understand, Travis, why Fremgen and Edelson would have stipulated not to play the rest of that interrogation. I just don't. I don't get it. I've tried.
Well, so Eric Jose, Richard, and I did a segment on it. It was I was the show before that. A lot of people were commenting on it. You know, so I went and watched the last 20 minutes, and there was a lot of stuff in there from Barb that possibly I didn't think was worth the trade-off, but there was some stuff with Barb, and I'm not blaming Barb. And if she's here, you know, I love you, and I'm sorry about what they've done to your family. You know, I don't think anybody had anything to do with the disappearance and death of Teresa Hallbach and your family, but you know, she's distraught, and you know, she's been told by people that you know, were taught from a young age to trust and respect the law enforcement in our communities, that, you know, we're sorry, but your brother has drugged your son into this, and so the natural thing for her to do is, oh my gosh, and so, you know, there's some stuff in there that can be taken both ways, and that's the only reason I can think why they decided to do that. But you would have to ask them, and of course, you know, the court standard in Wisconsin, they actually call it Monday morning quarterbacking. It's just not allowed, and the fact that it was a stipulation means it's strategy. So it's just totally off limits on appeal, which is what I'm talking about today. But
Right.
you know, and so hopefully people understand, you know, on the legal part of it, why didn't Nyrider and Drizzen pound on that in addition to just the you know, the coerciveness of it, and that would be the answer. It's legally off limits. But going back to the underlying point, these frustrations that Dr. Silkman mentioned on the forensics, that just got mentioned now about the confession tape, other things we've mentioned about what happened at trial or what didn't happen at trial, and that those things not being at the forefront in the appeal, or more specifically the 97406, it's because, you know, once you're convicted, you know, it flips. We want finality. We want a quick resolution. We want that you only get one shot at this stuff. Even though the practical realities, Zellner did a very good job in her briefing leading up to the Court of Appeals decision about all of the things she had done, all of the things they were doing, what they were in the process of doing, including working in conjunction with the state on agreed tests and so on and so forth, you know, just got brushed aside, and were just treated as of no significance. You know, that's the way the court works. You know how it works. If you wanted it, that you had additional time to do this other stuff, you should have put that in your motion
by having reservations about additional stuff. You should have informed the court. And, you know, I think she was really hoping, as we all were, that the court took a little bit more discretion in looking at the equities of the thing. But, you know, we've already talked about what the people in Wisconsin, their viewpoint is, and so on and so forth. It shouldn't really matter what their viewpoints are. It should be the law, but, you know, the circuit court judge, Judge Flowers, even if it was procedurally barred, you know, the law says in her discretion she can still determine on the merits, even if there's a lack of a good reason for not bringing it in an earlier one. It's in her discretion. And of course, we saw where her discretion went. You know, it went totally against Stephen. And then the standard for overturning that is abuse of discretion, that's nearly an impossible standard. Just trust me on that. But abuse of discretion is
really high bar.
Intensely high bar.
Travis, just to highlight that, because you and I privately spoke about it last night, I think it'd be awesome for you just to relay a little bit more to the panel here and obviously the people in chat. But when we spoke and we're going through the courts of appeal, and you said the discretion of the procedurally barred, but you can rule on merit. And when we went back over the court of appeal, we found when we were looking at it, and I was highlighting it, they did actually do that. They did rule a lot on merit, which is what they allowed to legally do. And that kind of they split it in two parts in a sense, didn't they? They're like, we're affirming Judge Angie Flowers on the terms of the procedurally barred, but we're actually going to up the bar and give you what you want. We're going to review it on the merit, Kathleen, because that's what you're asking for. You're asking for us. You're saying that Judge Ange basically hid behind the procedurally barring, and you wanted her to rule more fairly on the merits. So we're going to do that for you. When we looked at it, it appears they actually did. They gave it that balance in a sense. So the argument kind of lessened for her then, because they covered both aspects of it. Would you agree?
Oh, yeah. You know, if Jack, if you can hold the paper back up for a minute and go to should be page 11. I didn't page number them, so you're going to have to count down. But at the very top, it says claims deemed procedurally barred in State v. Avery.
Yeah, give me just a second.
If that, I think it's page, hang on, I'm looking at it now. Oh, why is my page?
I can get to page 11, yeah.
Yeah, page 11.
Yeah, so those are the ones that were procedurally barred, and there's some good issues in there. You know, not investigating, number 2, investigating suspects. 3, they handled in another claim, and that wasn't, I don't think that was going to. But number 4, look how significant 4 is. That's blood in the sink, which is her entire theory went to. If you look at number 1, well, there was another issue that they should have had an expert to explain to them why their theory that it was law enforcement that planted the blood was wrong. That's number 5. And after the bones got tossed, maybe Dr. Silkman can talk about this. So regardless of the right, wrong, whatever on the issues being procedurally barred or not, after the bones, they denied the testing on the bones, and they determined that the evidence. So follow me here. So there's no rapid DNA testing, and there's no means to test the bones microscopically or any other way, or examine the bones to determine if they're human or not. So those 2 things are out. What's her strongest arguments? It seems to me it would be the blood, and here all of that is procedurally barred. But maybe there's something I'm missing on, so we've got, look at all of this stuff that got tossed.
It's a long list.
Number 4, number 5, 6 is 6. Well, I don't think was that big a deal, because when you look at what that expert said, I don't think it was, that wasn't going to be the biggest thing in the world, that, it was a sub-key. The court said, well, you haven't shown that she wasn't using the sub-key. You're assuming she was using the main key. That number 8 was important, that Fourth Amendment challenge on the search warrant. That's the groin swabs, which was a linchpin in the her expert on the possibly FL and the key. Number 9, hood latch. I don't know if those DNA things were more important than the blood. To me, it was the blood. I don't know if Dr. Silkman's got an opinion on that.
Well, I mean, for me, and I've discussed this at length with Kelly and many others on the panel, the most important piece of forensic evidence against Stephen is the presence of his DNA within the RAV4. Now, even if his DNA is within the RAV4, it doesn't mean that he killed Teresa Horbach. But Stephen never came up with any type of story or scenario to indicate how his DNA, in terms of like blood, got in the RAV4. So the assumption is if that Stephen didn't put his blood there by being inside the RAV4, it had to be planted. That's an assumption, right? His blood had to be planted. So definitely the core issue that the judge and any jury will always come down to. You can dispute many other aspects of the case, but if this is rock solid evidence against Stephen, i.e. if Culhane didn't fabricate the presence of his DNA within the RAV4, anyone must explain how that blood got within the RAV4. The other important thing is the identification of the bones. That's crucial. No bones have actually been tested. And what Zellner should have argued was the fact that Eisenberg had the means to identify those cremains as either human or animal. All she had to do was basically place them under a microscope or do immunological analysis like was done with Christine Rudy. That's how they identified the bones in the pit as being animal and not human fetal, right? So Eisenberg had the means to identify those cremains as human. She didn't do it. All she had to do was place the bones under a microscope and look at them morphologically, because human bones are very distinct compared to animal bones. She did not do it. So to me, and also Culhane used up all the DNA sample for the key and the bullet, which means that no one can now secondary test those two pieces of forensic evidence. So there is a lot of weaknesses in the state's case. And the state, remember, went with a circumstantial case against Stephen.
Well, it's circumstantial, but you read Buting's book, and he describes what these rural towns are like in Wisconsin. And specifically, they were hoping for college-educated or above jurors, and he talks about what they ended up with, and it's like they didn't end up with anybody with a college education, but they still had some good jurors, and that was going to be a real tough road to hoe. I wasn't when I read. And I don't know the answer to this, but it just seemed to me that it's fine. She had no choice. The blood vial was out. They did everything they possibly could do with that. And, Kathleen's doing not what she feels in her gut. She's got to go with what's left, right? What's left? Well, the vial's done. So
the vial is done. The vial is definitely done.
Even saying there's blood in the sink, there's blood in the sink. Even Buting talks about there's the photographs of the blood in the sink. There's like someone wiped right through the center of it. There's a piece missing. So you got a trail of blood, a rivulet of blood, small, and there's a piece missing out of it. And he's saying that, and of course, Kathleen in Ma'am 2 says she keeps saying, but they wouldn't listen. It's not law enforcement. Well, whether that's posturing or she really believes that, it matters not. But that's what she's got left. So of course she's going to go with that. And then, but when I read when I got I read the motion for post-conviction relief that she filed, the original one, 2017. I read that in real time, within a day of it being filed. I think that was 6 or 7 months before Ma'am 2 came out, because I had all these friends asking about it. The first thing I read, I don't read the body of the motion. I'm going back to all of the experts. And so I'm going through and I'm looking for the DNA that it's going to be aged, and well, that ain't here. And then, okay, here's the blood drops, and here's the DNA, and I thought, well, this is real creative and real. But the key thing for me was her blood spatter person, and I think he did a tremendous amount.
Well, that actually was her blood spatter expert really put a hole in the entire state's case, because they were reliant on accusing Stephen and Brendan,
not enough for appeal, not enough for 97406, not enough that it would meet the standard of it would have been a different result. And that's the context, whether that should be the right standard in order that we make sure everybody has justice, has a fair trial. I don't know, but that's what it is. And it's just not enough. And I think she's hoping, everything cumulatively, when you consider it, might be enough, but they didn't do the analysis that way. They did it one at a time, and and they, the wording of the opinion, and just looking at it from the appeal side of it, it's and that's the troubling aspect, that although all of the science is good, it can only go so far, unlike DNA that can do 1 in a trillion people or 1 in 6 billion on mitochondrial DNA. You just don't have those sorts of things, and and they refer to the DNA and the RAV4 in the opinion in an offhanded way. They said, well, this wouldn't have made a difference as required because of the I can't remember the exact phraseology, the overwhelming other evidence, and they're talking exactly what you're talking about, Dr. Silkman. They're talking about the DNA and the RAV and the because appellate judges aren't gonna, unless they happen to be former PhD microbiologists, they're not going to know any more about DNA than the trial judge. And so,
well, that you're correct. That's the issue. The assumption is if your DNA is present, then you were there. You placed your own DNA there. And there's a lot of anecdotal evidence and experimental evidence to suggest that that is indeed not the case. You can have secondary transfer there, and plus, at the end of the day, we have to explain how Stephen's blood and DNA got in the RAV4. If we can find that out, if we can find the source of that blood, because Kelly has also done experiments using her own blood, and when blood congeals, when it clots, it's extremely difficult to rehydrate and to use it as a source of planting, which means that if you're going to plant blood, Stephen's blood, from the sink, you have to get it really quick, and you have to make sure that it's in a liquefied form and then plant that blood in the RAV4. That's technically quite tricky. Now, I could understand how you can swap swabs. That's very, very easy to do. And the only issue is this, and that is the blood that's present on the fabric of the car, the cloth. That is difficult to explain because that's where the DNA methylation team used that blood, that sample of blood on the seat cloth to obtain the age, the methylation age of the DNA. And further, that same team was able to determine that that blood actually comes from Stephen Avery, right? So hence, you now have an independent lab that proved that that blood was Stephen's. So now you have to think of a very elaborate way of how that blood in liquefied form was able to be placed on the car seat. Do you understand what I'm trying to get at here? So it's a bit more. Kelly can explain it because she's done the experiments. I understand all the biochemistry of the clotting, but I'll tell you what, once the blood is clotted and congealed, it's very, very difficult to get it back in a liquefied form for easy transport and manipulation and planting. So it is a challenge.
I'm going to add this in because this is something that's just come up in the last 5 days. And that's this call that Poggle made the morning of the 6th into the transporting of the vehicle. I can't prove that it's the RAV, but it sure seems like it can't be anything else because there were no other cars that were seized at the time. If that's true, that the RAV was, taken off the property and taken somewhere local, this is speculation, guys, but there is some roots to back that up because they definitely transported some vehicle the morning of the 6th to the crime lab.
Can I just ask about that? Because Kath did a bit of investigation last night and found logs. I think she might have sent them to you, but
Yeah, I already had them. Duke.
So the logs show that the lady, the dispatcher Marie, goes and signs in at the Avery salvage yard at 10:09 in the morning, and then leaves at like 10:31 or something, and then checks back out. And this is after the phone call, so obviously she's making her move to move it. So at this stage, if she's going to the Avery salvage yard, is that what she's picking up something from the Avery salvage yard? And if that's the case, and that's happening after 10 o'clock, doesn't that kind of, in a sense, maybe not be the RAV, because the RAV at this stage is now being going through with Groffy and being presumptive tested at the lab at the same time?
Well, Groffy wasn't called until Groffy testified. He wasn't called until mid-morning of the 6th.
Mid-morning, yeah.
11:11 a.m. 11:11. It was.
He wasn't even called. So I for the longest time until I reread his testimony, I thought he got there first thing that morning. Like 6, 7 o'clock. But that's not true at all.
But do we have any evidence that the RAV was moved off the Avery salvage yard on the
Ertle's testimony.
on the 5th?
Ertle's
and
testimony.
so there's no other photos showing that it literally left the actual Avery salvage yard?
No.
There's no photos or videos of the RAV4 being placed on the flatbed truck and taken to the crime lab. None whatsoever.
No.
Well, it just appears from those logs, whatever it was, she went to the Avery salvage yard to pick it up. So I was just trying to work my head around it, going, well, unless the RAV sat there the entire day, it doesn't make sense that she's going to pick it up if it already had gone that night.
Right.
Because then don't they have an excuse that the reason why it was even late, 2 hours late to Madison Crime Lab, was because there was a detour or something and they didn't get it in till 1 o'clock in the morning?
A storm.
A storm. So then that would be not just a deliberate lie. That would be a fabrication of a completely that's an extreme thing.
That's right. And there's another.
Where did we get flatbed truck and the RAV?
Well, they got this flatbed and a trailer to enclose it.
Okay. All right. Because all of the testimony was it got loaded in a trailer.
Enclosed trailer, yeah.
It was an enclosed trailer. That's correct.
Yeah, enclosed trailer.
Okay.
The point I was going to say was when the RAV4 got taken to the crime lab, they had to call another company to back the car out and put it into the crime lab. That's call somebody else to take it out.
Yeah, Travis, I've spent days trying to run this down. I've asked pretty much everyone in the community to help me. But at this point in time, according to their documentation, there's not one other car has been seized. Not one. The Grand Am and the Avery flatbed was in Crivets, and they weren't seized until 12:15 p.m., hours after this call. And it's in Crivets. So I don't know.
Okay, but so what's the driving time from Crivets to ASY?
God, someone's got to help me out. It seems like it's about 90 miles, but I can't remember exactly.
Okay. Well, it's hard. It's like listening to one half of a conversation. You can kind of piece it together, but so there's two calls that you uncovered and played recently. Well, there's a whole bunch that intrigued me, but every call I'm having to type, can he replay that? And I'm like, wait a minute, remember? But anyway, so on these two, we got this call where he calls the dispatcher, says, I need somebody I've deputized, I can do it. And you're going to follow a car to Madison. Now, so I'm thinking, and then that was brought up during that show. I was just in the chat, but so they're up in Crivets, but that doesn't mean Crivets is only going to get them. Crivets ain't going to take them to Madison. They don't have the manpower. And if you hear all of these calls, they're borrowing manpower. Manpower. There's no manpower. So, I don't think it's that big of a jump that he had arranged, okay, I need, you're going to go up and you're going to bring it back down to our county. And then, but here's what I don't, what are they following? What's the need?
Chain of
Now, I
custody.
can understand if they're driving the car down there, but they wouldn't
No.
do that. Wouldn't
No.
drive the car to the lab and contaminate it, surely, but
No.
who knows? And so she's following the car. And Madison's a trek. It's an hour and a half, 2 hours, I think, right?
Yeah, that's right.
And so, I could see she's following a car to take the officer back. That doesn't make sense. That she's following it simply to mean that it's secure. They didn't do that with the RAV, the most important piece, but it was enclosed. We know that ultimately, what vehicles for sure do we know ended up in the lab? We got the golf cart, the Grand Am, the RAV4, but not his new pickup.
No, they processed it on the spot, and the Avery Sarge flatbed was also taken to the Madison lab, and they processed his Ford F-350 on the spot.
Well, maybe now here's what would make sense: that they loaded a car on the flatbed and drove the They didn't load. Did they load that flatbed on another giant flatbed?
They probably got a wrecker to pull it. I know this.
Actually, I think they said Chuck drove it.
Okay. Well, there you go.
I hear what
remember
you're
reading
saying. That's just a super weird phone call, but the other one is weirder. I heard you got bones. Yeah, and they're jumping and shouting with glee and blood
Body
in
parts.
the RAV, and we got this, that, and then we got to take what's the other thing? I'm paraphrasing it, but he never identifies. Well, we need to get 2 cars back. We're getting 2 cars back. We need to separate the cars so they're not contaminated. That makes no sense. You can't put 2 cars in a giant building with the windows rolled up. Maybe not. So they're in 2 different bays. Okay, let's rent 3 bays because we got that other thing. What's the other thing? Barrels of bones?
No, the barrel stayed. Well, I guess they were in Madison. There was I'd have to re-listen to the call. Damn it.
Is the other thing the golf cart?
Could be. That was
The golf cart's one of them.
Yeah, that was the return when they brought them back from the Madison lab for long.
And I think they also brought the RAV back, right?
On the 11th, that's correct.
But the point is, there's stuff in those calls. You listen to them, and then you get 5 different people with a different perspective. Case in point, there was some calls the day they were searching, and Pam McGod found the RAV4. Well, there were some officers talking amongst themselves that was recorded, and a call to the other. And there was that comment, yeah, boss wants us to go back out there today and get permission.
Yeah,
Because the searchers are out there today,
that's
which
right.
tells me they were aware and they were, you know, what Pam said. Yeah, we got there. The crowd had already, most of the searchers, they had already gone. We got there late. I said I wanted to go the last place she was seen. He told me that's really not where we were searching, but okay. I need a camera. And then, so I don't think it lynched up that they were acting on behalf of law enforcement, but it was clear that the sheriff knew that whoever's organizing the search, whether it's Ryan and her brother or,
Scott
her
Blodor.
parents, but all of that was organized and well known to everybody. And what you can ultimately draw off of that, but these phone calls help get from, instead of A to Z, it's like you get from A to B and then D to E. It's filling in stuff.
That's right.
But on those trucks, that one call, I'm like, well, if they're up in crivets, because it's just natural. People know, so you don't list every detail. It's just, I need somebody to follow a car. A vehicle is what he said. A vehicle. I need someone to follow a vehicle to Madison. Get somebody who I've deputized. And then she volunteers, and then, okay, what the hell is she following? And then it's like, well, we know these are up in crivets, but, and that's the key. I know Jerry and Dean would have wished they had all y'all doing all of this stuff a month or two going into trial, because it would have. That's where you have to hit it in pretrial, or look at all of the stuff you guys find in pretrial transcripts. Sometimes that's the nail in the coffin, so to speak, on the arguments you all are making, because unless somebody gets questioned about, okay, where were you? When did you come in? The tow truck driver, for example, testified in both trials. Unless who backed the RAV4 into the trailer, unless you call these people and really question, then you're faced with a lot of assumptions that you have no way to independently verify. But you have logs when those vehicles showed up, so that's pretty darn good. Now, was that those phone calls, the two we're talking about, were they timed? Do you know what time they were?
I do. The call
No
from
time
Poggle,
reference.
the Poggle call, the first one was at 8:10 a.m. on the 6th.
Yeah.
And then you skip forward. Maybe Susan can remember. It was like there's like 3 of these calls. I think it was like 10 o'clock or so. Marie called back to dispatch. Isn't that right, Susan? Do you remember? Something like that.
Doesn't seem like it was that late. I'm sorry.
Yeah, I can't remember it, but I'm going to take all the relevant calls about this particular thing and string them together and thumbnail it, and everybody can decide for themselves. Another part of this, and you're right, it is a bit confusing because there's another part that comes into this on the same day. And it was when Sipple called early in the morning looking for Jeremy Hawkins. And Joyce, she was the dispatcher, she says, oh no, he's been gone for about 30 minutes. And he's like, are you sure? Are you sure he's gone? Send the bailiff or somebody down to the, the warehouse or whatever, and just double check. Well, then come to find out, Jeremy He wasn't in the dispatch center, but he was in the garage watching this trailer of the burn barrels waiting on the crime lab to arrive. So it's kind of a little bit confusing there as a separate issue, though, because I first thought that's what Marie was falling back, but no, that's a separate thing completely. So,
Could we, Jack, get you or Kelly or Alice to ask in chat what we're obviously going to need to pick up, but if there's anything that they want us to start with on another segment, but we'll dig more into some of these things, like the things that got barred, and we'll dig more into what the court's rationale was and why they said things were conclusory, or why they said things were misleading at least 3 times, and dig in to that. And I'll have it all set up in slides with the actual language of the affidavits and what the court said. And then we'll even go to Kathleen's brief. We won't take the Court of Appeals word for what Kathleen said. We'll dig it out, and we'll line those up. Maybe Kelly can help me do a side by side, 3 rows. What the affidavit says, what Kathleen says it says, and what Court of Appeal says about it.
Yeah.
We'll do that. And then, because I think it's important for people to understand on the legal side what level of logical connection you need versus what level of logical connection you need amongst us friends that things make logical sense. Like some of the things that Dr. Silkman said. And we can even look at some of those that, there's a logical connection here. What would it take maybe to get it to the level that the court says it needs to be? But I think we for sure will do that. But if anybody has anything they want us to dive into whenever we do another segment, we'll get it all prepared so we can go through it quickly. I enjoyed talking about it. I'm going to stick around and talk about or listen in on whatever you guys are going to talk about from here on out. I really enjoyed it. I hope it was educational and helpful.
That was fantastic.
Really,
fantastic, Travis. Fantastic.
Yeah, really good.
And Dr. Silkman, where are you? Melbourne or Sydney?
I'm in Adelaide, South Australia.
Okay, I'm gonna go out. I'm coming to Australia. I don't know if you heard. I'm gonna do a grand tour. I'm gonna come and see you, buy you a pint.
Well, that'd be awesome. We could do a podcast as well.
Yeah.
Fantastic, Travis.
All right. So I'm going to listen in, and I'll be here if the question comes up. But if people will comment about what they would like to focus on next time, don't worry if we didn't get your question answered this time, either from Discord or those in. Alice, you'll help me go back through, right, and dig out what we weren't able to answer, and we'll answer them next time.
Alice is gone, I think.
Oh,
does she have?
Maybe Kelly. I'll get with Kelly. She'll help me.
I'm onto it. I've been updating our sheet as we've been going along, so you'll see that when you go into it, you'll be able to see it live that I've crossed out all the things I've already done. So, and I've been updating. So.
Well, I didn't mean to interrupt your flow, Jack. Please go on about the vehicles and those calls. I'm fascinated by that myself.
Well, I mean, go ahead,
Jack. Well, I'm looking at the map of Wisconsin, and I'm thinking that Travis may have a good idea that it could be the Grand Dam. They could have brought it back there because from Crivets to Madison, that's quite a trip. From Mishcot to Madison, I mean, that's 2.5 hours.
I haven't found. Well, maybe
And
that's possible.
it's an
But
hour
there-
and a half from Crivets to Two Rivers or Mishcot, whatever.
I haven't found anything that tells me that those vehicles were brought back to the Avery salvage yard, and certainly not at that time of the morning. Nothing.
Yeah, we need chain of custody on the Grand Dam.
As far as I know, the Grand Dam and the flatbed were taken by Skurlinski from Crivets to the crime lab. That's what but I'll dig into it more, see what I can find. Maybe I'm wrong. I was wrong about Groffey. I thought Groffey was called first thing the morning of the 6th because Earl testified that the RAV arrived at the crime lab at 1, 2 o'clock in the morning. So
on 15.
I just assumed that Groffey was called first thing, 5, 6 o'clock in the morning. Get your ass in here. We need to take some photos of this car. But that's not what happened.
He also, Groffey testified that the RAV left Avery salvage yard at 10:45 p.m. and arrived at the crime lab at 1:15, which is 2.5 hours, which is what my map is showing me. That's the time it takes. So why has there always been this extra hour in there?
I was thinking that the RAV left before 10:45. I was thinking, I don't know why I was thinking 9 or 9:30.
No, you're right, Jax. I read it yesterday as well. It was apparently left at like 9:30 or 9:45 or something is what I was reading in the documentation.
Okay, maybe it was 9:45.
Yeah.
I just looked at Groffey's testimony. 10:45. Okay, so there is an extra
it's in
hour.
CASO report. I think it was a CASO report. I found that they're stating it was earlier, that the RAV was moved around 9 something in the night of the 5th.
Right.
Right. Well, I'm going to dive more into it. I'm going to find everything that I can find. I mean, we've got a lot so far, but I'm going to dig into the aspect of the Grand Dam and the flatbed and see what I can find. Probably through the DCI reports, but we'll see. We'll see what I can come up with. And then, of course, I'm going to string all these calls together. There's probably 3, I think, at least, from the morning of the 6th. That's what I'm concentrating on.
And don't forget to send them over, Jack.
Oh yeah. Once I get them strung together, I'm going to send them to you for denoising and get them cleaned up. Absolutely.
Fab stuff.
Yep. So number one, really, Travis, we don't really have anything else planned. This was your night, and Cal to get this out because the glimmer of hope, is those of us that have advocated so long. I mean, I don't know Stephen, I don't know Brendan. I'm advocating for the truth. Whatever the truth is, wherever it takes us, that's where I'm going. And it's not that, I mean, I certainly have a lot of empathy for Brendan because I think he really got screwed, like royally, many times over. But doing the right thing, investigating the right way, that's where my heart is. That's where it's been for many years. I want the full truth. So wherever that goes, that's where it goes. But understanding now where are we at and having you on to help us understand the process of what these courts really want. I think that's really important. And it's not to lose sight of hope. There's always hope. If you don't have any hope, then maybe this arena is not for you because it's a hard road. I knew long ago this was going to take a long time. I knew it, and made the decision to stay with it. So, big thanks to you guys for you and Cal for putting this together. Whenever you're ready, we'll do it again, and I'm going to label this in part 1, and we'll just continue on with part 2. I'll leave that entirely up to you to complete because this is extra work. You got a real job, you got shit to do. I get it, I understand. So you just have to let me know. Susan,
if this day and time is good for people, I'm good for next week. If you want to do
absolutely
something else,
no, that's fine. We'll just continue on with part 2 next week. It's good for me. mean, since our standard time is 5 Central, I started a little bit early because I knew there would be a lot of questions. I understood that. And I'll probably do the same thing for next week. I'll start at 4:45 Central so we can get into it a little closer to, the top of the hour, so to speak. Yeah, that works for me, Travis. I get it scheduled and you guys can prepare whatever you wish to present. I think we must understand what's happening. I mean, it's great to cover this old ground. It is. But now is where we're living, and that's what truly matters at the end of the day, right?
Yeah, it does, but I don't want to squelch or kibosh. How do you like those for 2 words? The enthusiasm for research and especially the the hyper technical asset we have with Dr. Silkman, and he came on Eric Jose's thing to kind of just explain very early on, way before foul play was even thought of. But I think, I don't mean to put words in Dr. Silkman's mouth, but I think he he explained it during Eric Jose's segment that he was in other groups regarding, other topics and kind of grew wearisome from that, and then saw an opportunity here to share real information on topics that, although I've had DNA involved in cases, I had really good experts. I don't know anything about it. I can't talk about it. And, I do know why red blood cells don't have nucleuses. They do when they're first made, and then they shed the nucleus, but there's a reason for that. I learned from Dr. Silkman. Do you know, Jack? Why
I've
red
heard
blood cells?
Well, I know the white blood cell retains it, but I don't know I can't remember the science that how Dr. Silkman explained it. But I do remember listening to Eric Jose and Dr. Silkman talking about it from years and years ago. I do.
Red blood cells shed their nucleus very quickly after they're made in the spleen and the bone marrow, because mammals have capillaries that get down to 1 cell in width, and they have to fold to actually make it through the capillary, and they couldn't do that with a nucleus.
nucleus.
So
Wow.
thank you, Dr. Silkman, for that. But anyway, I don't want to squelch the enthusiasm for the FOIA requests and the
Oh, no, not at all.
combining and collating and synthesizing the technical, scientific, forensic with the information from the phone calls, which, back in the day, all we had was queso, remember? And then, the transcripts and people, focusing on that at various times, remind people, remember, they testify to this and because there's way too much to know. And, but I thought it would be, you said people had a lot of questions about the appeal process, which of course new meant, because we're in the now and we're in the middle of the appeal process, that it was important for people to know that there's a distinction, a difference. There's a difference on what Dr. Silkman may need to justify an opinion in the academic realm or the research realm. And then there's a standard, obviously, for the 97406 realm. And those standards don't apply. The standard that applies is our common sense, right? And sometimes we'll hear an opinion and not think much of it, or we'll hear an opinion or a theory and, oh yeah, that's interesting. And what
what are we missing to connect all of that? That it's just different, so that hopefully people understand why things are presented or not presented, or why did the theory switch, or why is this person being looked at, and that's about all I had to say on that. I try and avoid the personalities of the lawyers involved or
Sure.
the stuff, but if people are getting stuff out of it, then we'll dive deeper into that one aspect to start, and then we'll let them know what else there is, and if they want to take a dive into that, we'll do that. But I really, really enjoyed it. Always enjoy hearing you guys and listening. And
Well, Travis, again, I can't thank you enough. You're a working lawyer, and it's your time. We do this just like you. We do it for free to help us, each one, understand the case and to advocate as from our beliefs of what we can glean out of these old documents, these newer documents, and everything in between. And as you said about these calls, we're going from point A to point B to point C, and then we have to take a kind of a leap here because there's a blank spot, and we go to spot E or F because we're missing, and it's really difficult. That's why I've tried to avoid and ask everyone. I mean, I've asked people that have been involved in the case as long as I have, help me understand this. What am I missing? And I haven't gotten an answer yet. So anyway, okay.
Hopefully we will. I would be remiss in not thanking again Cherie for offering to help on law review articles and whatnot. Next time we'll talk about that other expert on post-conviction in Wisconsin. I'll have an in-depth thing on him. And thank you again, Kelly, for helping me assimilate the questions and grouping them coming in, and keeping up to date on that, along with the information I needed on the post-conviction briefs. I really appreciate it.
Absolutely.
You're very welcome.
Absolutely. So with that said, unless there's questions from the live chat that I've missed, Susan, have you seen anything, or Cherie or Andy? I've been trying to look, but I haven't really seen anything. Just some general chatter. So I think at this time, and we've been rolling here 3 hours and 52 minutes. So let's go down the list here and get final thoughts before we say goodnight. So Andy B, final thoughts.
Well, that was really, really good. Thank you very much, Travis. It illustrates how the justice system has to be very robust, and also illustrates the task that Kathleen Zellner has got. And it may also indicate some little dubious tricks and sidesteps that the Court of Appeals or the state has played as well. But yeah, thank you very much. Much appreciated.
Thank you, Andy. And Cherie, I don't recall. Final thoughts.
Thank you very much for taking so much of your time to help us learn these things. Really appreciate it.
Yeah, thank you for all you do too, Cherie. It's much appreciated. And Susan, Sister Susan, final thoughts. Can't hear you. Your light's not working. Uh-oh, Susan's got a microphone.
Can you hear me now?
There we go.
Sorry. Thank you so much, Travis. It was very educational, and appreciate having those questions answered. I had a couple of them in there, so appreciate it very much, and I look forward to next week.
Thank you, Susan. JD, final thoughts. JD may be asleep. I don't know. I think he's in a little bit later time zone than I am. I'm in the Eastern time zone. So, Kel?
Yeah, I think there's only me gassing up to be asleep, to be awake at 2:45 in the morning, Jack.
Yeah, there you go. Kel?
Yeah, thanks for having me. Thank you, Travis, for speaking to us today. It's been very educational, and I just I'll be still working in the background, and I'll get all the stuff together for you.
That's wonderful, Kel. Thank you so much for doing that. Again, we do this for free to help us ourselves and to hopefully help educate. So, Travis, I know you've kind of given some final thoughts, but is there anything else you'd like to add before I get to Dr. Silkman?
No, I've said it all. Thanks for having me. I appreciate it. I enjoyed it.
Absolutely. And we'll get the next one scheduled. Dr. Silkman, final thoughts.
Yeah, I just quickly want to say what a fantastic effort by Travis and also Kelly putting this together and everybody else putting the questions. I really think this type of an event is so crucial. I mean, we may be doing a lot of debunking on a scientific level, but it's all got to fit within the context of a legal framework, right? There's no point in having all these good ideas if you can't present it in a professional legal manner in front of a judge to decide upon. So I don't have a legal background, and I'm really appreciative, like everybody else is on the panel and in chat, that we can get a real attorney coming on and to give his thoughts about the process and explain some of the concepts which, most of us are just dumbfounded on. Why did the judge say this and why did the judge do that? Getting his opinions and explaining the legal process is crucial, and it absolutely complements what we do. Under no circumstances, Travis, do you think it's putting away from our research? Quite the contrary, it's complementary and absolutely needed to have that. And again, thank you, Travis. Thank you, Kelly, for putting it together. Thank you very much.
Absolutely. And my final thoughts are, which I've already said most of them, is a huge thank you again to Travis and to Kel for, putting together this question, answer, and education in our legal system and how things really work and what these judges really expect and what they look at. So we'll get the next one scheduled and we'll just continue on, hopefully with our education next week. And yeah, with that said, I'm going to say this has been a Foul Play production.